All right, everyone, please whisper.
On Mr. Gilday, Judge,
Yes.
the reapproach on that, he's scheduled for May 15th for the mental health court. I think this court date was a status to see about his entrance into that program.
Okay, I already reset that.
It was to May 7th.
Yeah, do you want it on a different day?
Would it be possible, Judge, for you guys to reset it to the May 15th, the mental health court date?
What's the cause number, do you know? Well, you know what, his name is,
It's on there.
oh, just 1 second. Okay, 2025.
CR
Mhm.
006971.
We were just looking to see about on the same dates because he rides the bus. He's currently at Cross Point, so for just to come two times in 2 weeks, it might be a little bit difficult. But he advised me he's meeting with Crystal and abiding by the terms of the program and looking forward to be successful in the program.
Awesome, how are you doing?
I have a word to tell you,
Yeah.
if you allow that.
Yes.
Of course.
I know I have a word, and I know I look very bad, but I want to come back to the good one. When I was 11, I broke my private part, and it felt 4 years
Okay,
ago.
let me just tell you this.
Maturing at an old age. I was at a bus stop.
So
Let me just tell you right now, number one, you don't look bad. You're looking great today, okay? So I always tell people, wherever you start in life, that's your starting point. It's not supposed to be your ending spot.
Just started learning things.
Yeah.
Instead of learning that, you were saying,
Yeah.
I have like 10-year-old break.
So this is the thing about the program you're going to enter into. We're all going to want to help you. That's how the treatment programs are supposed to be. So the thing is, you got to reach out for the help. If you see yourself struggling, don't think you have to struggle alone, because we're all there to help you and we want you to be successful, okay?
I would appreciate any kind of good words towards the rehab,
Mhm.
so I can have a better life. 'Cause I got school. Should have done that at a young age. I just been hurt, and I healed 4 years ago. Was recovered. So I need to step my life up and be an adult now. Make good despise godly moves in life. I want to go to school. So I've been in school for a month and a half.
Oh, awesome. What are you taking?
Right now reading, I'm about to take my finals reading setting.
Okay.
So I just got
Yes.
So here's the thing.
Sorry.
You're doing
Get it
great.
done. I just would do it later on. If that's okay, I heard I have 12 months.
It's a 12-month program at minimum. There might be.
Starting from when last week.
Starting from when you signed it.
Yeah, it was like, I think,
Oh, wow.
April 13th, or it was about a week and a half ago.
Is that okay, Judge? That,
Sure. I mean,
can you try to remove it? I mean, I want to be in college by the time I get out, and I'm growing up now. I'm not gonna be enough of it, I promise.
all right. So here's,
I'd be out at the bus stop.
let me just tell you the way things
When I
work.
first
Yeah, no problem.
wrong people, wrong crowd at outside, you know.
So let me tell you the way treatment programs work. And specifically this treatment program. This treatment program is a pretrial diversion program. So what that means is if you complete everything, it's not going to be on your record. If you decide, this program is too much for me, I think I can do it on my own, then what will end up happening is your case will go back to an originating court, and they will proceed with those charges, whatever those charges are.
That's what we don't want.
Yes, get bullied a lot, because I'm very not like manly, because you grew up late always, and I'm old, and I was self-defending myself, but I was still in the wrong for being in that situation. I shouldn't be bullied. I shouldn't be outside. I shouldn't have a cigarette in my lip. And now that I'm going to school, my mind is developing like if I'm in the 12th grade. Now I'm older. And my mind is a lot younger. Like the things I should have done at 18, I was hurt still. I did at 24. And I look back and I say, I can't really have delays. No, I don't want to delay. I want to get my education. I want to go to college. I want degrees. I was looking into psychology, sociology, math, science, business administration, business management, data analysis, computer science.
Well, I'll tell you, this is a program this program will work with you on that.
That's the only way. I learned the hard way. 10 years of me out there, it was no good for me.
Yeah.
That's why anything you ask, I'm willing to tell you a lot about it.
Oh, thank you so much.
Yeah, I'm not hiding anything from you because my family, they're cops, they're in the army.
Mhm.
I made a terrible decision to go to the streets.
Mhm.
I didn't join the gang. I didn't do any of that. I never shot anybody, I never stabbed anybody. I never robbed nobody. I never did drugs. I just am like a kid that went out when the parents said, my parents on church, they said, don't go out. I went out. They said, don't go over there. I
And you
went over
did.
there and I got in trouble a lot. And the first confession, and that had lives of my education. I was hurt.
Well, what I can tell you is this program,
my mind, I was hurt, but it's better than that.
well, I will tell you, this program is to help you get on track. And we want you to be on track, okay? So what I'm gonna do is I'm gonna reset you. And you wanted it when?
If we could respectfully, Judge, May 15th, that's his mental health court setting.
All right, so we're gonna reset you for May 15th, okay?
You're a great woman. You have a good heart, and I appreciate everything you're doing for me.
No problem. And thank you so much. And like I said, where we are in life, we're all of us are trying to improve. Like I'm on my path of improvement. We just try to make improvements every single day. And that's what you're doing. So I appreciate it. And I want to let you know, I see that you're doing that.
You gave me the light of the day today for the rest of my life.
Great opportunity for you.
Oh, thank you.
Yeah.
Does he need a reset form or would that help? Would you be helped by having a reset form?
Yes, if the court wouldn't mind, Judge, just so I guess he has the paper. With
No,
them,
we could just a reset form for the 15th.
Maybe,
Yes,
excuse me, Your Honor?
yes, thank you.
Morning, Judge.
Good morning. So on your client, they're saying that the competency evaluation.
I just wanted.
He's scheduled in magistrate's court for that on May 18th.
Right.
So if you want, the elevators are broken, they can bring your client up if you want to stay for that, or either I'll reset this after May 18th.
I've had a difficult time referring with things, so.
All right, just reset.
Yes.
All right, well, before you all do that, let me see.
We had entered a plea and we were here on a sentencing,
Yes,
and you had questions about his competency.
competency. All right.
And I've already had him once reviewed and the doctor found him competent, but
All right, now I remember this. So, all right, so he's scheduled for May 18th. I don't know where they are as far as the evaluation in magistrate's court for competency, but what we'll do, Norma, set this for the beginning of June. And counsel, if it's done sooner than that and you want him brought sooner than that, then let us know.
thank you, Judge.
I can do first.
All right. And do you want us to cancel his appearance?
I'm
Do
sorry.
you want his appearance canceled today for court?
Yes.
Deputy Laura, you can send him back. All right. Veronica, this is our docket. So those are the people, and that's a matter of public record. Those are the people who are on docket today. And so I have to go through all of those cases today. Yes, actually, it's a light docket today. Juan Rivas. All right, so all of the discovery is in,
What's my form?
and you have the transcript.
We got the transcript, Judge.
So
All I need to tell.
We have everything we need.
when I have people come up to the bench to speak to me, then there's all this chatter over here. So let's wait till that chatter is done. All right, so the other thing, has an acknowledgement of discovery been completed?
I have no memory.
I don't have it. If you could,
We'll get that
I
done.
think. I want to say it was March 16th.
It's probably better to do one now with all the new stuff I just came.
All right, so they'll do that. So counsel, you've received all discovery then?
I have, Your Honor.
And offer was tendered
Yes.
and you're rejecting the offer? State, how long do y'all expect this trial to last?
This particular charge arm, probably still be.
All right, All right, knowing the parties as I know the parties, it'll probably be 3 days.
That's right.
Oh, no, because I know you guys just get to the point and ask the questions that need to be asked.
What if we go past a week?
Oh,
Do we get something in return?
let me just tell you,
Props?
the first civil trial that I ever had, there was time announcements, and the time announcement was 3 weeks. And I'm like, this is insane that this is lasting 3 weeks. So I'm over there trying this case.
Okay.
And we ended up having a Matlock moment, which was great.
Mhm.
And then I kept getting called on the criminal side. Oh, we need you over here for trial. I'm like, I'm currently in trial. They have me checking in every day. I said, do you realize on the civil side, when they announce for 3 weeks, it's exactly 3 weeks.
Yeah.
And get this, the judge does not let you go over 3 weeks. So if a witness went longer than anticipated, you're only going 3 weeks. And they cut everybody off. It's like, it's going to the jury now. You only had 3 weeks. All right. So Norma, need a jury trial date for them. If y'all will confer, 4 days,
We can do June 29th.
June 29th. All right, you'll be back on June 29th for jury trial. Court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court.
That's right.
All right, thank you. And counsel, once you have signed the acknowledgement of discovery and you've signed the reset form, you're excused. Just have a seat and they'll bring the reset to you.
That's right. Yeah.
Thank
I'll be
you.
right with you. Thanks. Yeah, that's all I get for that.
All right, who's next?
Page 5, fourth one down, John Glover.
John Glover.
Judge, I just wanted to approach, that's why I put my name on the list. We're gonna,
This is a case, Judge, that we were doing a felony reduction on. I did process the PC affidavit and information complaint on 413 and sent it through the process. It's currently waiting with the misdemeanor judge presiding this month, Judge Dominguez, waiting for signature. I went ahead this morning and asked the office assistant, that's our liaison with presiding judge of the month, to ask if it could be rushed since he is in custody. So that's one.
Okay.
and I was just gonna try to save them from having to bring another person if we could. I'm gonna try to plead him in jail court if I can, so.
See, this is what I'm talking about. You see how women are able to multitask? That's what we do. And I'm going to be doing that all week because Mother's Day is coming up on the 10th. Don't wait till the last minute to get flowers, right? All right. So when are you all expecting this to be done?
The paralegal said hopefully by Friday, if not Monday. So, and then we sent
And
the
then-
out to rush. So
Yeah.
probably.
All right. So Norma, let's recall this for mid-May. Is that good for everybody, you
Yes.
think?
Yes, Judge.
Mid-May?
The 21st.
Sure.
All right, May 21st. And if, of course, if everything is taken care of, you won't need to be here.
Perfect.
And Deputy Laura, she said you can cancel her client.
Yes, thank you.
All right, thank you.
Thank you, Judge.
So what's happening there is they're refiling it as a misdemeanor. Now, normally you can plead somebody up here, right? And just do a reduction to a misdemeanor. But sometimes it's better because you don't want your client for anyone to see that it was originally a felony. So they're going to refile it as a misdemeanor case. And so it will only show up as a misdemeanor. All right, who's next?
Page 7, third one down, Jesse Arguello.
Jesse Arguello. Look in the purple.
Thank you, Judge.
It's supposed to be an LSU purple, right?
There you go. Glad it makes you happy, Judge.
Yeah, it does. So where are we on discovery?
Judge, this is the first setting. Just looking to see the lab. We got the labs. Gonna discuss the offer with my client. We got one today. I think we may have everything. Just gonna go over it one more time with you.
Okay, how old are you? All right, Norma,
Yeah.
I need a plea deadline date in 3 weeks.
Thank you, Judge.
Thank you.
Appreciate it.
Once you sign the reset form, you'll be excused. What date?
Okay.
All right, May
Thank you, Judge.
21st. Thank you. So I always do plea deadline dates because otherwise cases will drag on and on. And I'll set plea deadline dates depending on, is it a complex case? What is the age of the accused? Because usually if they're 18, because this is felony court, right? And 18-year-olds, 17-year-olds sometimes end up here. And then if they're certified as adults, they end up here. And normally when you have teenagers, they need more time to think about the consequences of any actions they're taking. Yeah. And so I usually give them more time because sometimes they want to discuss it with their parents. You know, although I always tell them, you really should have been discussing this with your parents before whatever actions you're accused of taking were taken, you know?
Right.
Omar Wright. Thank you for dressing appropriately for court.
You're welcome.
All right.
Judge,
Where are we on discovery?
I don't know yet, Judge. I was hired. I just got my notice of appearance in yesterday.
Mhm.
And I am going to be pulling discovery this weekend. I do have a plea offer already, but I haven't had a chance to look at anything.
All right, stay. On this case, is all of the discovery uploaded? It's Omar Wright, page 6.
Was all the discovery made? Yes, Judge.
Okay. Thank you.
Sorry.
No problem. All right, how old are you?
43.
All right, Norma, set this for a plea deadline date at the end of May.
Judge, can we have June 1st? My end of May is really packed.
Norma.
Yeah.
Is there a date for the beginning of June?
Yeah, you do first.
All right, June 1st.
Thank you, Judge.
You're welcome. Once you sign the reset form, you're excused. All right, who's here on Montejo? All right, and where is Montejo?
Here you are.
Thank you. All right, so this is a sentencing, and I'll explain that to you after I finish.
Okay.
And to coordinate everyone's calendars to get that completed. So once he's placed on probation, maybe he just reports as normal until he's actually put into the program. I did speak with John earlier. He came by and that was the update that I received.
See what I mean about women multitasking?
You're welcome.
All right, we're gonna get, you want to proceed?
Yes, Your Honor.
Thanks. Court is calling 2025 CR 013499 State versus Anthony Montejo. Could I have parties announced for the record for the state?
Megan Galloway for state.
Defense?
Roberto Vázquez, defendant, ready to proceed, Your Honor.
All right. And Attorney Galloway, this is one where you all have agreed for probation. We were only doing a PSI to see if Veterans Treatment Court will accept him. He has been accepted, so I'm just sentencing him today. So you're excused. Thank you.
Thank you, Judge.
All right, so. And counsel, you reviewed the PSI report?
Yes, Your Honor, with my client.
All right, any objections to the PSI report?
No objections, Your Honor.
All right. This is what the court will do. The court will find you guilty. Court will sentence you to 2 years in the state jail facility, suspended and probated. I'm going to do 2 years, but they may end up extending you or wanting you to be extended because sometimes Veterans Treatment Court is longer than the 2 years. But for now, I'm just going to place you on for 2 years, okay?
Yes, Your Honor.
There's to be regular reporting by Zoom or in person, regular random UAs. Cindy, you need to cough drop of water. We're done. Oh, no. Go ahead and get some water. With regards to the 10 days in the Bexar County Jail, I can do that by GPS because that's what they're requesting.
Was it house arrest or just,
I can do partial. Are you employed?
but he does
Right,
take his
so-
children to school.
Okay. Then I can do GPS for 20 days partial, waive the fees, and I'll allow him to transport the children to and from school.
Swim class.
All right, so here's the thing.
Yeah.
If you're wanting to do other activities with the children, then it's gonna end up being 30 days. Now, if you have somebody who is willing to do those things for you for 10 days, then it will be GPS for 10 days.
What is GPS?
It is a device that lets us know where you are. Because here's the thing. They're requesting 10 days in the Bexar County Jail. So if I were to send you to 10 days, and we're still on the record, Cindy. Oh, okay, no problem. If I were to send you to the 10 days in the Bexar County Jail, you would only do 10 days and you'd be done. If I'm giving you GPS, if I give you GPS and it's full GPS, which means you can't leave your home, then I'll only do 10 days. But if you're asking to do other things and make it partial, depending on what you're asking me for, I could probably go up to 30 days or 20 days. You want to take the children to school, you want to take them to their activities. So then that would make it 30 days GPS.
Can I just do the school then?
All right, then if you're just doing the school, then it would be 20 days GPS.
And that would be just at the house?
That would be for you to take them to and from school.
Okay.
If you want only 10 days GPS, then that will be full house arrest, which means for 10 days, you have to be in your house. You can't leave your house. Do you need to discuss that with your attorney?
Yes.
All right, I'll let you all discuss it. So anyway, Veronica, some DWIs, it requires jail time as a condition. Yes, we're back on the record. So what does he prefer?
20 days, John, and just to take the children to and from school at this time.
All right, so 2 years state jail facility, suspended and probated for 2 years, regular reporting by Zoom or in person, regular random UAs, $1,500 fine that will be probated, $60 restitution to DPS for testing. There's to be 20 days GPS, partial for transporting children to and from school. So that will be the only thing you can do for 20 days, okay? So if you're driving and people want McDonald's, you can't stop because that'll be considered a violation.
Thanks for clarifying that.
Yeah, because sometimes people will do that and then I'll get notice that it's been violated, okay?
Copy.
Field visits 1 time per month for 3 months. 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, 100 hours will be deemed satisfied. And a deduction of 1 hour of the community service restitution for every sober support meeting completed. DWI education course, VIP panel, ignition interlock for half the term. A 2-year license suspension.
Any chance we could do 180 days on that, Your Honor?
No. And let me see. Intensive outpatient treatment with probation. The referral to Veterans Treatment Court. Court will note that the defendant has been accepted. Proof of employment within 45 days. No employment as a home health care provider or with minors. the conditions I'm giving you for probation, with the exception of the GPS, once you are officially in Veterans Treatment Court, they have the court's permission to change those conditions, okay? Probation, is there anything else?
So good.
Is there anything else you need from the court to be successful?
Very good, thank you.
All right, you're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, and if I didn't say it before, Ms. Abrams, the GPS fees are to be waived.
One last thing, Your Honor.
All right, thank you.
Can we delay the suspension for 15 days so you can apply for an occupational license?
No.
No.
I'm not allowed to do that
You can't.
legally. Yeah. All right, good luck to you.
Thank you.
You're welcome. James Parker. All right, court starts at 9. You got to make sure you're on time. You understand? All right. So today is plea deadline date.
Yes, Judge.
Yeah.
So we've reached a plea bargain agreement. We'd like to accept it. I do have a hearing in Comal County though at 1:00. And so I'd like to come back tomorrow if the court would be willing to entertain a plea on this case tomorrow morning. We can.
Well, I mean, it's how far is Comal County from here?
It's about an hour.
All right, so if you all get, and what time is your hearing in Comal County?
It's at 1.
Oh, if you guys get it done, I'll take it up and put you in front of the line.
Front of the line?
Yeah.
All right.
All right,
Sounds
thank
good.
you.
Thank you, Judge.
You're welcome. All right, so where are we on the restitution?
Judge, I did bring, I don't think the state would obviously object to this wherever they are, but this is the restitution that's been paid.
Okay, so it's been paid?
Yes, ma'am.
All right. Awesome. All right, so we're going to go on the record. In 2025 CR 015165 State versus Matthew Hill. Can I have parties announced for the record?
Kevin Collins for Mr. Hill, Your Honor.
And are you Mr. Hill?
Yes.
All right, so Mr. Hill, you entered a plea on April 16th. On that date, the court found there was sufficient evidence to find you guilty. The court deferred finding of guilt as you had applied for deferred adjudication. According to your plea bargain agreement, it was a $1,000 fine to be probated. There's to be restitution of $12,398.73 to the complainant. The court will note that the court is in receipt of payment of $12,398.73 that has been paid to North Park Lexus. Counsel, if you'll make sure that probation has that.
I will, Your Honor.
All right, state, you may be excused. All right, anything you wish to say on behalf of your client?
Judge, no, he regrets his bad decision. He's made the complaint as whole as he could with the restitution, and he's currently working in a different job and doing well and raising his family. So we apologize to the court and the victim.
All right, so what do you do for a living?
At the moment, I'm working as a gas station clerk
Okay,
for now, so find a better job.
all right, this is what the court will do. There's a $1,000 fine that will be probated. Regular reporting. All right, everyone, let's not rush probation. If you all could have a seat, she'll take you all up. Are you able to hear me now? And Ms. Abrams, it is State versus Matthew Hill, 2025 CR 015165. You're welcome. So it's a $1,000 fine to be probated, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. There's to be restitution of $12,398.73 to North Park Lexus. The court will note for the record that restitution has been paid in full. There's to be 100 hours of community service restitution. Do you have children?
Stepkids.
All right, what are their ages?
One is 10, there's 11, 13, and 16.
And they live with you?
Yes.
All right, I'm going to order parenting classes. 50 hours will be deemed satisfied once parenting classes are complete. The remaining 50 hours will be deducted upon completion of the probation. Do you think it's appropriate for felony theft course or MRT?
Felony theft course.
All right, once felony theft course is completed, the remaining community service hours will be deemed satisfied. Field visits one time per month for 3 months. And the court will sentence you to 3 years deferred adjudication. Probation, is there anything else? All right. And then with the regular random UAs, it can be regular random UAs or either the patch. Probation and your counsel will explain that to you. The patch is more expensive, but then you don't have to sit around and wait for your UAs. All right, anything else that you need?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. Thank you.
Thank you, Your Honor.
Thank you. Who's next?
Ryan, first on page one down.
Ryan Westbrook. Yes. Good morning. What's the update on?
He's still in custody, Your Honor. According to the scheduling order, he is not. I do not believe he's taken a plea as of yet, but his. So I don't know. I don't quite know whenever sentencing or resolution of the case would occur.
Okay, so because he was set for jury trial in federal court on March 30th, that's what y'all told me the last time. So what's?
I think that was, yes. It was set for jury trial, but I don't think that there was no trial on that date, Your Honor. But I don't have a date as of yet for sentencing.
So is there anything on PACER?
The last thing I have, Judge, is just that last setting date for the trial. There was no trial on that date.
So there's no date in PACER?
I have not looked at that this morning, Your Honor. I can do that, or at least contact the office to have that.
You'll look at it.
Yes, if I can just step aside for 1 second, Judge. Thank you.
All right, thank you. Who's next?
It is Jonathan Aguilera on page 5 at the bottom.
Okay. I'm sorry, Norma, which page?
Page 5 at the bottom.
Jonathan? Hi, Aguilera. All right, court starts at 9. You got to make sure you're here at 9. You understand?
He did call me at about 9:04 a.m. Your Honor, to advise me that he was running late, and I didn't see that until about 40 minutes thereafter. Profusely to the court.
All right, where are we on discovery?
I do believe we have everything, Judge. There was an issue brought to my attention. He wants me to, or not, something to look at in the video. So I am going to bring officers of the pre-trial. So if we could have a short set for me.
All right, how much time are you all asking for?
I believe a standard 30-day should be fine. That way you can do that, and then we can confer based upon those findings. We believe that there may be an issue regarding the legality of the stop, or lack of reasonable suspicion, Judge. But I brought it to the attention of the state today in reviewing the videos. So that I think they want to look more and see about the things from the officer's perspective to see if they can corroborate that.
All right, I need a 30-day reset. And you can just put it as a discovery date.
I could do May 29th.
Yes, ma'am.
All right, May 29th. Once you sign the reset form, you'll be excused. You need to make sure you're on time. Okay. All right, thank you. Oh, thank you. God bless you too. Heather Gonzalez. Hello, good morning. Oh, counsel, you're on this side. That's the way the deputies
Been a
want.
while here.
Yeah, how's it going?
Good, how are you?
All right, I cannot complain.
Yeah, me neither.
All right. All right, how's everything with the baby?
Oh, she is getting big, but I'm dealing with my postpartum, so
But
I
most,
appreciate you asking.
yeah, but most importantly, is she running the household, which she should be doing?
Oh, definitely.
All right. So on this case, where are we on discovery?
Judge, I believe the state's turned over everything to us on this. There might be just a few items remaining, but I did turn over to the state some mitigation evidence.
Okay.
They're going to review that. I'm scheduled to send them an email on a video that was taken at the time of the incident.
Okay.
So we're requesting some time for that.
All right. 45 days, enough time?
I believe so, Judge.
All right, Ms. Ferguson, if you can recall this for 45 days, please.
May I, Your Honor?
Yeah.
I have a vacation letter on file. If we could do it the following week.
I'm not going to let you have both vacation. I'm not having vacation.
I'll get on.
All right, Norma, you can put it after that date.
Yes, ma'am.
Just a second.
Yes, Your Honor.
We got to let attorneys have vacation.
All right.
All right. We'll see you back on June 22nd. Once you sign the reset form, you excuse. Thank you for dressing appropriately for court. All right, thank you.
Thank you, Judge.
Sure.
Talk soon.
Okay, awesome.
Okay.
All right, so where are we on this case?
Yes, with regard to the discovery, Judge, this is a little bit.
Oops, you're okay?
Just a little bit, this is a little bit of an older case because he got returned back from the competency court deeming him competent. And looking at the discovery, there's some files that are too big for download, namely some statements. So I did provide the state with a drive that we can get those. I think we're on the same page of requesting a 30-day reset so I can get those, evaluate that and see where I need to take it from there.
All right, Norma, I need a 30-day reset.
Can you do the 29th with my other one? That way?
Yes.
Okay, great. A little more efficient time.
All right, May 29th.
Thank you, Your Honor.
Thank you.
Lottie, you want to sit down?
Just have a seat, sir. We'll take a minute.
All right, who's next?
Trisha Rodriguez, page 1 at the bottom. Trisha Rodriguez, page 1 at the bottom.
Trisha Rodriguez. All right, today is plea deadline date.
Yes, Judge. So something came up this morning about a possible coming up with some upfront restitution. I was talking to her father, and so what we're hoping for was maybe we could get a month for a plea deadline to see actually how much in the restitution we could come up with.
So is that something that's changing the offer or something?
Depending on what they could potentially bring up front, Judge, then it could change the offer, yes.
All right, and allegedly, what's the total restitution due?
So
Six figures, starting with a one, like 177,000.
she's indicted as a co-defendant. The co-defendant is a fugitive, Judge.
Okay. And allegedly, well, I'm not going to get into any more. All right. This will be the last extension for a plea deadline date. Ms. Ferguson, 30 days.
Thank you, Your Honor.
Sure. All right, May 28th.
May 28th.
All right, thank you. Once you sign the reset form, you'll be excused. Thank you for dressing appropriately for court. Good seeing you.
Judge. Oh, I've got some more action in here, Judge.
Oh, hey, okay. All right, who's next?
Next, same page 1, number 6 down, Rafael Rodriguez.
Rafael Rodriguez.
Good morning, Your Honor.
Good morning. All right, where are we on this case? There's a lot that's been, well, there's a lot of entries, but nothing has been happening. There's been plea deadline dates. There's been pretrial diversion. There's been offers that have been done. There's been motions to withdrawals that have been granted. So
Yes, Judge.
What's happening on this case?
We were just hired yesterday for Mr. Rodriguez's case. I did see the case notes as well, Your Honor. I saw that there was potentially some indication of maybe PTD consideration. I did have a chance to talk to the state this morning. I believe that PTD is no longer going to be considered. There will be an offer extended to our office after we have the opportunity to receive the discovery, take a look at the case. Mr. Rodriguez is already making appointments with our office to discuss as well. If we could just set it for a new plea deadline, I believe that'll be enough to move this case forward.
All right, Ms. Ferguson. Set this for a plea deadline date and jury trial date in 30 days. All right, May 28th, you're either going to jury trial or maybe y'all will have reached an agreement that's acceptable to the court. We shall see.
Yes, Judge.
All right, thank you.
Fun day, Judge.
Yes. Once you sign the reset form, you are excused.
Thank you, Judge.
Thank you.
All right, and counsel,
Yes.
the previous attorney completed an acknowledgement of discovery. So state if there's a new acknowledgement of discovery that needs to be done with counsel.
I'll get it taken care of.
All right, thank you. Thank you. Thank you. Who's next?
Same page one, fourth one down, Chris Cervantes.
Chris Cervantes. All right, so did you get an update with him on the impact on his license?
Yes, we have a deal worked out that's going to allow him to plead to a misdemeanor, but they're going to require him to serve some time in the county jail as a condition of probation. So I'd like to get a day to come back for a plea and so he can turn himself in on that day.
Let me ask you this. Who are you conferring with?
Miss Calloway.
Megan.
And we're very thankful that she gave this the time and thought she did. So
Okay, so when do y'all want this brought back?
we come back in about 30 days.
Norma, 30 days? If you can recall this for 30 days, and that'll be your final plea deadline date. All right,
Can we do the week after? I won't be back till the week of June, whatever that week is.
all right, thank you.
The week of June. Yeah, that someday that day's fine. Okay. All right. Thank you. I'll be here anyway. So
All right, June 8th?
Chris, have a seat. I'll get you to sign something.
Yes.
May I approach, Your Honor?
Yes.
Thank you. So on Ryan Westbrook, I do apologize, Your Honor. The last I showed was just that he had that setting date. But the more updated version shows that he did in fact take a plea and will be set for sentencing on July the 14th, 2026 at 1:30 p.m.
So it's July 14th?
Yes, ma'am.
All right, Ms. Ferguson. I need a date for Westbrook at the end of July.
July 30.
That sounds fine to us.
All right, and so he'll be in federal custody.
Yes, ma'am. Thank you, Your Honor.
And if you'll let the state know.
I will. We'll try to work all that out. I appreciate it.
All right, thank you.
Yes, ma'am. Thank you.
Pete Alcantar? Yes.
So my client let me know that unfortunately wouldn't be able to make it in court today.
Because?
He told me he was having transportation issues and
Okay.
I tried to get him in. I was wondering if we could maybe give him another day, Friday or Monday.
No.
Okay.
I mean,
If he doesn't come in, he'll get a warrant. You want me to let him know that?
oh, we're gonna have a hearing on it right now. I'll give him till 11, because there's Via.
Sure, I'll call him and see what we need.
All right.
Yeah.
Okay. Who's next? Deputy Laura, on page 3, Mr. Alcantar.
Yes, Judge.
He has till 11 o'clock. All right, court is calling 2025 CR 010725, State versus Arnold Pena. Can I have parties announced for the record?
Charles Bunk for Mr. Pena.
And Mr.
He's
Pena?
present. He's in custody, Judge.
And Judge, I would also like to point out that Ms. Lisa, the mother of the complaining witness, is here and she's ready to testify.
Oh, okay. All right, so, and you're Mr. Pena?
Yes, ma'am.
All right, Mr. Pena, this is what I will let you know. Whether witnesses are present or not has no bearing on my decision on whether or not I'll allow you to withdraw your plea. Do you understand? You need to say yes. All right. So the court heard evidence on the defendant's request to have his plea withdrawn. We had a hearing. Is there any further argument from either side before the court makes its decision on that?
Judge, I think the evidence that we had last time spoke for itself. Mr. Pena testified that he never met with his attorney, that there was no discussion of any kind regarding self-defense. And we have 2 jail calls from prior to his plea where he says that he was going to plead self-defense. I think that the deception that the defendant is trying to pull in the court is very evident. I think that should be weighed against him and take on his motion that says that he had no knowledge about self-defense or whether it could be pled or parameters or things like that.
I would just remind the court, the testimony that while there might have been discussions of self-defense, not until the actual day of the plea did they actually discuss the legalities of it. And more importantly, as was testified from the other lawyer, my client wasn't allowed to see, there's videos of this offense. He wasn't allowed to see those until he was in the box on the day he was set for trial, and then forced to make a decision at that point. So in addition to the self-defense claim, I'm very concerned about his lack of ability to make a fair and just decision, having not had an ample time to review the discovery with his attorney outside of this jury box prior to the day he was set. And when the jury, as I understand it, the jury was in the hall or something similar to that. So for those reasons, we asked the court to grant the defendant's motion to withdraw his plea.
All right. Defense motion to allow the defendant to withdraw the plea will be denied. Defense, are you prepared to proceed to sentence?
If I can just go over the PSI briefly with my client.
Yeah.
Give him a couple of minutes.
All right. Thank you. All right. The court is calling 2025 CR 015787 State versus Alicia Jimenez. Can I have parties announced?
For the state of Texas.
Sharon Thorne for the defendant, Your Honor. Alicia Jimenez.
All right. Thank you. All right. Ms. Jimenez, you entered a plea to count 1. According to the plea bargaining agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $1,500 fine. State is silent on your application for deferred adjudication. They're taking in consideration 2025 CR 015767-02. There's to be no contact with the complainants, and there's an affirmative finding of deadly weapon. Did both parties have a chance to review the? Yes, yes. Yeah, no, that's okay, Rick.
Yeah.
All right, yes. All right. Have both parties had a chance to review the PSI report?
Yes, Your State has no objection.
No objection. I've reviewed it with my client. No.
All right, the state is silent. Any witnesses?
Yes, Your Honor. Before I get started, I would like to call her daughter, Destiny Stewart.
All right, Destiny Stewart.
Jimenez, over here. Put your back against the counter. Your back.
Good morning. All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
My name is Destiny Stewart.
All right, defense, you may proceed.
Thank you. Destiny, how are you related to Alicia Jimenez?
That's my mom.
Okay. And how old are you?
28.
28. Do you have children?
Yes.
How many children?
I have 5.
5 children. And do you live here in San Antonio?
I do.
Okay. Is your mother, and she's not in jail, was she a part of your life and your children's life?
Yes.
And how attached are your children to your mother?
Very attached.
Okay. Does she help you raise them?
Yes.
Are you asking this court to grant her deferred adjudication so that she can continue to be in the community and help you and your children?
Yes.
Okay. Do you believe that that would be in the best interest of your children and of your mother?
Yes, they will.
Do you understand that if she were to be granted deferred adjudication, there she would have to do probably a lot of things with probation, go to classes, report, and stay out of trouble? Would you be willing to support her in that way?
Yes.
And would you make sure that either she had a ride or was going to all the classes and things that she needed to do?
Yes.
And do you believe that your mother would be successful if she were to be granted deferred adjudication?
I do. Yes.
Okay. You are aware that your mother has some criminal history,
Yes.
but you're not making excuses for your mom.
No, absolutely not.
You're just asking this court to take a chance on her and give her a chance.
Yes.
Okay. That's all I have, Your Honor, of this witness.
All right, any questions? All right. I have a few questions.
Yes, ma'am.
Any objections?
No.
All right.
Can ask you some questions.
So does your mother have any mental health issues?
Yes.
And can you tell me what that is?
Don't know too much of her health issues, but I know she does have some. I know when I was younger, she would see a doctor. She wouldn't really tell me much of why she saw a doctor, but when I was little, she was pretty much stable. When I became an adult, it's kind of when things got more rough.
Okay. All right, thank you so much. Next witness.
Your Honor, before I call my client, I also wanted to, I filed a sentencing memo and I think you should have a copy, but the letters that you have attached to your sentencing memo came out really blurry, so I have a hard copy.
Thank you.
This is my sentencing memo
Any
along with.
objections to the court reviewing this? Just give me one moment.
Sure, and there's 2 letters attached to that, and then I have some newer letters here, Your Honor.
Oh, have you reviewed those letters?
I haven't, I just got these. Okay.
Thank you. All right, any other witnesses?
Yes, Your Honor, I would like to call my client at this time.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. And is there any objection to the court reviewing the PSI report?
No, Your Honor.
Okay, so just give me one moment with that. All right, so when questioning your client, if you can clear up for me, because in the PSI report, it's stating that she is minimizing guilt. And in the PSI report, she seems to argue that this is self-defense and that she has no idea what's going on. So if she wants a jury trial, then, we're here for that.
Ma'am.
All right.
Proceed.
Yes.
State your name, please. Alicia Malik Jimenez. And you understand why we're here today?
Yes.
And you pled no contest to this offense of aggravated assault, correct?
Yes.
Okay. Now you understand what the judge was asking, and those are some things on the PSI that you and I discussed. And you tell the judge now today, do you accept responsibility for what happened?
Yes, I do, Your Honor.
And you understand the charges against you?
Yes, I do.
Are you asking for a jury trial?
No, I'm not.
Are you making excuses for what happened?
No, I'm not.
And you understand that there was a complaining witness, a victim in this case?
Yes, I do.
And that's why we're here. And you're asking this court to grant you deferred adjudication, and you're not making excuses for what happened.
No, I'm not.
With that, Your Honor, I'd like to continue with questions.
All right, so she's not going to be alleging self-defense.
No, Your Honor.
Okay, all right, you may proceed.
Thank you.
Thank you.
Okay. Now, you and I have gone over this PSI, and we've gone over the facts of the case. We've gone over your criminal history, correct?
Yes.
And you acknowledge and own your history. You know what you've done and the things that, in fact, you've been to prison before, right?
Yes, I have.
Okay. Knowing that, you were still asking this court to grant you deferred adjudication and give you a second chance.
Yes, ma'am.
Your mother's here, correct?
Yes.
And your daughter's here. Your mother, she went to TDC, correct?
Correct.
And in fact, when you were 14 is when your mother went to TDC and you ended up in foster care.
Correct.
Would you agree that that kind of started the spiral of problems that you have?
Yes, that's true and correct.
Okay. But again, we're not here making excuses, right? Okay. Now, since you've been in custody here in Bexar County, is it true that you've been involved in Bible classes?
Yes.
And would you agree that you've kind of awakened your spiritual side?
Very much so.
In fact, that letter from one of your fellow inmates, they recognize that you are doing much better and you're kind of a leader at the jail.
Yes.
And you are trying to be better and trying to have a better life for your children, for your grandchildren,
And my mother.
and your mother.
Yes.
Okay. You wrote a letter to the judge.
I sure did.
And would you like to read that letter?
Yes.
And
Is that okay with you?
With your permission, Your Honor.
Well, it's fine with me. However, the state will need to review it.
Okay. Okay.
And then once they review it, if they're fine with that,
Okay.
then I
Thank you.
will listen, of course.
And while they're reading it, could I ask for some more questions?
Yes.
Okay. Now,
We'll just.
so, and I know you told probation and you tell the judge that you have some serious health problems. High blood pressure,
High blood pressure and.
severe asthma, depression, you've been diagnosed with depression, anxiety,
Anxiety.
bipolar 1 and 2,
Yes.
PTSD,
Yes.
and ADHD.
Yes.
Do you take medicines for those diagnoses?
Yes, I do. I was enrolled in Alamo Premier. That's my psychiatrist. And I also take medications here in the County.
Okay. So prior to your incarceration, you were seeing a counselor and therapist?
Yes.
And if you were to be continued or granted deferred adjudication, you would continue with that? And they would monitor your medications?
Yes.
And they would make sure that you're seeing, is it a psychiatrist you see?
Psychiatrist and a counselor.
And a
at the same
counselor.
place.
Okay.
I was gonna leave that out.
Oh,
I
no,
Just
wrote
have
letter and I
a
was gonna
moment
leave
with
it
my
out.
client.
Sure.
Yeah, I was gonna leave it out. I know it was, yeah. Yes, I was gonna leave that out.
Okay.
I'm nervous. I'm sorry.
It's okay.
I apologize.
Okay.
It's been a long 8 months.
Yeah, no
Okay.
problem.
Can I read it to you?
Yeah.
Sure.
I can basically just tell you, that I wanted to apologize to my victims, apologize to you, Judge Boyd, to my attorney and to the district attorney, and especially my family for putting them through the pain and the cause. With that being said, that it doesn't define, the reports do not define who I am. I'm a very loving mother. I'm a very loving grandmother. And I care for my mother who is here, who is ill. I was known to have sufficient, I have been known to have, be sufficient and dependable. I'm a caregiver, like I said, to my mom and a provider to my grandbabies. I've also surrendered myself to the Lord Jesus Christ, who is capable of forgiving, healing, and changing me for the better. I come before you to ask if you would consider giving me another opportunity to a fresh start, to a new life, and to a better career to educate myself. I want to be a service to my fellow church. I also want to help change lives. I was thinking about trying to get into prison ministries to help the broken and to minister them. And with that being said, I just wanted to be able to share my accomplishments with my family. And I want you to know that I would make better choices. And thank you for your time.
All right. Thank you so much.
Yes, ma'am.
All right. Any other questions?
No, Your Honor, I believe she really said it all. We were just asking, on behalf of her and her family, for you to consider deferred adjudication. I know it's kind of thinking outside the box with her record, but I believe that she's come to hopefully a change in her life. And I think we would have a good choice in granting her deferred. And as I stated in my sentencing memo, if you were to give her deferred, you would still have a big, huge hammer over her head. And if she messes up, I explained this to her, she's looking at 20 years and you would have that over her. But I think, and I hope that you would consider deferred adjudication and that place her on 10 years deferred adjudication with all the bells and whistles that are needed. And I do believe that she'll be successful.
All right. So, Ms. Jimenez, this is what I can tell you. It would be nice if I had something in front of me that could tell me how people will behave or whether they will be successful on probation or not, whether or not if I place them on probation, they're going to commit new offenses, but I don't have that, right? So I just have to look at evidence before me and consider things as a whole, right? And so I don't think you would be a good candidate, and this is why. I don't think you'll be a good candidate, but I can tell you right now, I'm not going to sentence you to the 12 years. This is why I don't think you'll be a good candidate. You've been on probation before for assault, family violence. And I realized that was a long time ago in 2001, but it was terminated unset.
Yes, ma'am.
All right. And your attorney knows what terminated unsat means. Now you have a lot of cases that have been dismissed. I'm not even considering those because they were dismissed. I don't know what they were dismissed for. You have a criminal mischief from 2009. You did time. They gave you a judgment satisfied. Then you had another theft case from 2018, judgment satisfied. A resisting transportation, that's the same time frame as the theft case, judgment satisfied. Then you had the abandoning of a child case. And with that, there was a motion to revoke file, and then they terminated your probation unsatisfactorily. Then the other cases where they say, oh, we dismissed it for a missing witness, I'm not considering that all because I don't have any facts for that. But then you had another aggravated assault with a deadly weapon. And for that one, you received 4 years in the prison.
Yes, ma'am, I did.
And that's from 2020. And now you're here on another aggravated assault with a deadly weapon. So that's why I don't think you're appropriate for deferred adjudication. So the court is not going to grant your application for deferred adjudication. What the court will do, the court is going to find you guilty. There's a $1,500 fine, time and money to run concurrent, take in consideration 2025 CR 015767-02. There's an affirmative finding of deadly weapon, affirmative finding of family violence. There's to be no contact with Ernesto Coronado or Luis Luvano. There's to be no unsupervised contact with minors, and the court will sentence you to 7 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you'll need to speak to an attorney. And what I will do, if I didn't say it, I'll put in there the therapeutic community for mental health. And I'll also let them know therapeutic community just based upon the stipulations for any type of drug or alcohol issues.
Thank you, Judge.
All right.
Yes.
Thank you.
Thank you.
Good luck to you, okay? Christopher Vroman,
Yes,
Yeah.
Your Honor.
and he's in,
He's present on Zoom.
okay. Let me,
He said he renamed himself, so you should see
Okay.
him on there now.
no, I'll admit him, he's still a Zoom user. That's okay, it happens. All right, Mr. Vroman.
Yes.
All right, what is happening with this case, counsel?
So, Your Honor, we're set for a discovery setting today. I was informed by the state that there is a new case that is likely to be
Okay.
filed. So we need another discovery setting.
All right. And is it
It's family violence. I just have another case with Mr. Prater.
oh, yes. I was
Sorry
like,
about
what?
that.
All right, so is it another family violence case that it's going to be?
The second case I have?
Mhm.
No, it's an act assault, but this one is family violence.
All right, and so the case, the aggravated.
Yes, two different clients.
Oh, no, I'm just here on Vroman right now.
Yes, so we need
All right, so where are we on discovery?
Yes.
Because today, the state was supposed to be prepared to tender an offer. Was that done?
New cases have come to office.
Okay, Ms. Ferguson,
Yes, ma'am.
I need a reset date for 60 days.
June 29th.
All right, June 29th, and that will be for discovery and state if you're at that time able to tender off a global offer.
Sure.
All right, thank you. And your client may appear by Zoom.
Okay, thank you, Judge. I have another one.
All right, who's the other one?
It goes, he's on page 9.
All right, and Mr. Vroom, you're excused.
All right, thank you.
Gallegos. State. All right, so on this case, where are we?
So Judge, we're set for a plea deadline today. I conferred with the state and the state did tender a new offer than what we had at the last setting. I need to take some time to meet with Mr. Gallegos, go over all the discovery, and he needs to make a decision about what he wants to do, if he wants to accept the offer that's been tendered or get the case set for trial. I was hoping we could get one last plea deadline so that we can have a final answer for the court on what we would like to do.
All right, Ms. Ferguson, final plea deadline date, 3 weeks, please. May 21st.
Thank you, Judge.
All right, your client can appear by Zoom.
Okay, thank you, Judge.
Thank you. All right, Mr. Gallegos, you're excused. Thank you for dressing appropriately for court, even though you're on Zoom.
Yes, ma'am. Thank you for having me. Thank you.
Have a good one.
You too.
Pete Alcantara. Pete.
He's not here, Judge. This is no checker. I'm still not here.
It's Brianna's. All right, court is calling 2025 CR 015215 State versus Pete Alcantara for the state. All right, this hearing was scheduled at 9 a.m. The defendant was due to appear at 9 a.m. Defendant has not made an appearance. It's 11:10 a.m. State.
We're requesting a bond for
Just one moment. All right, and state you're excused. Deputy Laura, did you make an announcement?
Yes, Your Honor, I did get that on.
All right, the court will issue a judge's warrant, remand the defendant without bond. All right, court is calling 2025 CR 015204 State versus Ruth Lopez. Can I have parties announced for the record?
Alexander Krause for the defense.
And Ms. Abrams, this is a sentencing.
Thank you, Judge.
All right, are you Ms. Lopez? You entered a plea bargaining agreement. According to your plea, there's a $1,500 fine. State is recommending deferred adjudication. This is run concurrent with 2025 CC 014144. Defense, any witnesses?
Yes, Your Honor. One.
Okay.
We'd like to call Joelle Vega.
All right, Joelle Vega. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, you may proceed.
Thank you for being here, Mr. Vega. What is your relationship to Miss Lopez?
I'm her son, firstborn.
And how about to Stephen Gonzalez?
I'm his father.
Okay, so she's Stephen's grandmother, right?
Yes.
And is it safe to say she's been involved with him his whole life?
Yes.
And how old is he?
He's 11.
Okay, and how's the relationship been over the past 11 years?
They have a good relationship. From the moment he was born, he required special attention, special needs. He was born with a birth defect. And she's been there throughout the whole process, through the surgeries. To the point where when he finishes surgeries, going to school, picking him up, taking him home through grade school, she's been a big part of that process when me and his mom had to work. So, at home, they've always been close, spending a lot of time together, so.
So would you say that she helps out like kind of with day-to-day things, like picking them up from school and that sort of thing?
Yes.
And would it cause hardship for you, and Stephen, if she weren't able to help out around the house and that sort of thing?
Yes.
Okay, do you have any concerns at all about her seeing Stephen or spending time with Stephen?
No.
Do you want this court to put a no contact order?
No.
So you want her in his life the way that she has been throughout his life, correct?
Yes.
Pass.
Good morning, Mr. Vega. Just a quick question. Mr. Vega, were you aware of the defendant's home conditions when this incident happened?
No.
Did you make any efforts to make sure that your kid was safe at the defendant's house?
Yes.
What happened next?
Good.
Okay, so did anyone else raise any concerns about the defendant's house? So you never went to the defendant's house whenever the kid would be dropped?
So when it comes to getting him to and from school, my mom would pick him up. In the earlier stages of his life, I wasn't around in that house a lot. That's the same house that I grew up in, and I was always out working and having time to figure out my own place to stay. So a lot of it had to do with me just not wanting to be in the house because my parents were there and my dad. But when I would show up to that house when he was a lot younger, I had no concerns with that, of whatever transpired. So.
Okay. And are you aware of the defendant's home conditions as they exist now?
Am I aware of it now?
Yes. Not the home conditions as they exist now. Correct, right now.
Yes.
And have those conditions changed?
Yes.
Are you sure about that?
Because I talked to my mom. She says she's done stuff around the house to make it better than what it was in the day.
Okay, so based on what you know, can you assure this court that the child will be safe around the defendant and the defendant's house?
I already talked to his mom, and I don't want him nowhere in the house. I don't want him at the house, but if, as far as like the no contact, like me and his mom agreed that if for whatever reason she wanted to get in contact with him, it would have to be at his mom's place. That we have to be notified first, and it has to be at her place, no question. As far as anywhere involved in that house, I do not want him nowhere in that house, period.
Any further questions?
Yes, so as far as the conditions of the house, you say that they've improved. To the best of your knowledge, would you say that the conditions of the house were caused by the defendant or perhaps someone else that was living there at the time?
It'd be both.
Okay, no further questions, Your Honor.
I have a few questions. There are no objections.
No objections.
All right, so I'm trying to consider whether or not there should be contact or not. And you said something when you were being questioned about you didn't want to be at the house. Is there a reason for that?
So growing up in that house, I had a lot of issues with my dad. We used to get into it back and forth. I have a whole juvenile deal that can validate that. And it's like when I look at the house, I see everything.
All right. And then the other question that was asked for you, and I'm just trying to follow up. When you said you think her house is different than it was at the date of the offense, have you been by the house? So you haven't seen it personally?
No, that's just from what I've heard. I feel that, you know, because of everything that transpired, she wants to be in this like she wants to fix everything, but it starts there first.
So this is what I can tell you. Are you aware of what the conditions were like in that house?
The day that I was notified when everything happened.
Because the child that's listed in this, was that your child? All right. So are you aware, and this is my concern, and this is why I'm trying to figure things out and have issues with contact with her. Because according to this, it says that rats were crawling around him and on him and biting him.
Yeah.
And that there are feces throughout the house. And that's the condition that she had him in according to the stipulations. So I just don't think contact with her is a good thing, because it's sort of, if you have this situation, how are you allowing rats to crawl on a child, and bite a child, and you have feces in the house? And when you have feces in the house and it's rats, people have died from that, because there's some kind of fumes that the feces gives off, and it's just not sanitary at all. And what you're telling me is that this child is special needs. So I don't think contact is appropriate, and I want you to understand why. Now, maybe after she completes parenting and does other things, and I'm going to have probation do field visits at her house to see how it is, because sometimes people will clean up for the time being, and then 3 months later, it's back the way it was before. And so those issues need to be addressed as far as mentally. Why did she allow her house to be this way? And why is Child Protective Services not concerned? Those are questions I have. Okay, but thank you so much for coming down to testify. I really appreciate it. Okay.
Judge, the mother tried to get here today, but she couldn't get off work, so she did write a letter. I don't know.
Sure, I'll see the letter if there's an objection.
Great.
Thank you. All right. Is there anything else?
Nothing from the defense, Your Honor.
All right, Jay, if there's nothing else, you may be excused. Thank you. This is what the court will do. There's a $1,500 fine that will be probated. Regular reporting by Zoom or in person. Regular random UAs or either the patch. Proof of employment within 45 days, no employment as a home health care provider or with minors. Field visits 1 time per month until further notice. No residing in households with minors. No contact with minors. This is run concurrent with 2025 CC 014144. Do a MIC evaluation. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. TAP evaluation out of custody, follow recommendations. There's to be no contact with the complainant. And the court will sentence you to 5 years deferred adjudication. Probation, is there anything else?
No. Never had unsupervised, or is that just no contact period?
No contact.
Thank you, Judge.
And once parenting classes are completed, the court will reconsider. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Probation, do I need to add no possession of weapons?
Yes, Judge.
All right, and there'll be no possession of weapons.
Judge, I believe the agreement was for 4 years.
No. That was a recommendation from the state for 4 years.
And then in terms of reevaluating after the parenting classes, she can revisit the no contact order after the
Yes.
field visits and the parenting classes are
Yes.
complete.
Yes.
Okay, thank you, Judge.
And so, and I just want you to know, I have to make sure
No, I
that
understand.
people are protected. Okay.
No, I understand. And I have no issue. I have no issue with complying with them.
All right. And has Child Protective Services?
They went to the house, they saw the house, and they spoke with Steven about the whole rat thing going on and everything, and they closed the case. They
Okay.
said there was nothing there, and they spoke with him, and he said it wasn't true.
Okay. All right. Thank
So
you.
I have no issues complying with anything.
All right. Thank you.
Thank you,
Who's
Judge.
next?
Daryl Fauntleroy.
Wait, are you ready? Has the paperwork been done? She has to go to Comal County.
Who? I don't know.
What's your client's name?
James,
James Parker.
it was right here.
They just turned it in. They just turned it in, Judge.
All right. If you'll swear them in and I'll take them.
Fauntleroy.
AL.
All right. Yes. What page is he on?
He's on page 6 down.
All right. I'll do Fauntleroy, then I'll take up her plea, and then I'll do Pena. Hello.
We can figure ourselves, Judge.
All right. So do we have an interpreter and an advocate, or we have?
We're a team interpreter. I'm doing the lawyer's confidential.
Okay. All right. Awesome. All right. So on this case, there's a plea deadline date,
Correct, Judge.
and where are we on that?
So, Judge, in between last setting and this setting, a warrant was walked for an additional charge against my client. It's still a PF case at this point. However, the state has amended their offer where the offer is now continues to plead to both cases to run concurrent. I've asked the state for additional discovery on the new case that I do not yet have, that I can properly advise my client about that offer. And so I'm asking for a new plea deadline setting if possible.
All right. When will you have the discovery?
This could be prepared for other cases that we were doing it, or it's a village registered case, those usually don't involve a lot of discovery, so I think I could give, if you can find it, basically for a day, we should be okay.
All right. To the interpreters, are you all able to come back in 30 days?
Your clerk will schedule it.
All right. I need a 30-day reset.
I think 28.
All right. We'll be back on May 28th, and that will be the final plea deadline date.
Okay, Judge, thank you.
All right. Is there anything else?
Not from the defense, Judge.
All right. Do you have any questions, Mr. Fauntleroy?
It's just.
Thank you. He's asking about trying to go home, Judge. That's what he's asking.
Okay. And have you explained that to him?
We have, Judge, yeah.
All right. Thank you.
Thank you, Judge.
Thank you. All right. Do y'all have the paperwork for her client?
No, she had things for me.
They're telling me 10 minutes.
2 minutes. 2 minutes.
Oh, 2 minutes, not 10. Yeah.
Page 8 to 3 down. Humphreys.
Humphreys. All right. What's happening with this case?
This case is with Brandon Prater, and I've conferred with him. He has made us an offer. However, I believe that there's outstanding discovery of an incident that is directly relevant to our case that occurred the same day.
All right. And what?
And that would involve, probably police reports, the detective's reports, would probably involve body cam.
All right.
And, so it's kind of where,
Is this the?
yes. Mhm.
Oh, okay.
So when will you have that discovery for defense?
Gonna take me a little while because that's something. Perhaps 3 weeks, Judge?
All right. Norma,
Yes, ma'am.
I need a 30-day reset for discovery.
Yes, ma'am. May 28th.
All right, May 28th.
Thank you.
All right, court is calling 2025 CR 016051 State versus James Parker. Can I have parties announced for the record?
State. Monica Corrala for defense.
And are you Mr. Parker?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Parker, did you review the application for deferred adjudication with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented? Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? You're gonna have to speak up.
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Parker, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $1,200 fine. The state is taking in consideration 2026 CR 001677. Did you understand that to be the plea?
Yes, ma'am.
Defense and state?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Judge.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 120 hours of community service restitution, the DOEP course, MRT, and regular random UAs. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, Your Honor. She don't exhibit 1 and all attack. No legal objection.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right, are you currently employed?
No.
How do you support yourself?
Right now, I'm currently looking for a job right now.
I'm sorry, what?
I'm currently looking for a job right now.
No, but how are you supporting yourself? Because it takes money to live.
Right now,
Are you staying by yourself or staying with someone?
family right now.
So what do you do all day?
Well, fix by things like that, maybe. I'm gonna look for a job, but like cool jobs, things like that.
Okay, so let me just tell you, I'm having so much trouble hearing you.
Yes, ma'am.
And I know you have bass in your voice, so I need you to raise it a little bit, okay?
Yeah.
Judge, he's suffering from a toothache. That's why he's slurred.
Okay. So if you're drug tested today, what are the results gonna be? You're gonna get tested today.
Okay.
So what are you gonna be positive for if you're positive for anything?
No.
Marijuana and anything else? When's the last time you used meth? Well, that's what this charge is.
I understand.
All right, you're gonna get drug tested today.
Yes, ma'am.
All right, 3 years deferred adjudication. There's to be regular random UAs. Regular reporting by Zoom or in person. Proof of employment within 45 days, no employment as a home care provider or with minors. Taking consideration 2026 CR 001677. There should be no residing in households with minors. Do you have any children?
Yes,
What are their ages?
6, 4.
4?
Yep.
Do they stay with you?
No, ma'am.
When's the last time you've seen them?
2 years and my son, I think. Okay.
All right, I'm going to order parenting classes. Community, 60 hours will be deducted from the community service restitution upon completion of parenting classes. How far did you go in school?
I graduated, Donna.
All right. The remaining 60 hours will be deemed satisfied upon completion of the DOEP course. There should be field visits 1 time per month for 8 months. There's a $1,200 fine that will be probated.
Thank you, Judge.
There's to be a TAP evaluation out of custody, follow TAP recommendations. If they recommend inpatient treatment, we'll start with intensive outpatient treatment. And there's to be a UA today. No later than 3 p.m. Probation, is there anything else?
Go over to drug court for that anyway.
Yes.
Nothing else.
All right, is there anything else you need from the court to be successful?
No,
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Probation, did you want to no possession of firearm with that as well? All right, and there's to be no possession of firearms. All right, thank you. Good luck to you.
Thank you, Your Honor. Appreciate you working me in.
No problem. Jason Mejia. All right, today's final plea deadline date.
I've received a discovery, Your Honor, and we have also received an offer, but we are not accepting.
All right, how long do y'all expect this jury trial to last? All right, Ms. Ferguson, I need a 3-day jury trial date.
Yeah.
Yes.
I also have a motion, Your Honor.
Okay,
June 29th.
that's the earliest.
I have May 19th.
All right, see y'all back on May 19th. All right, and what do you have for me to sign?
It's a request to have to change the no contact order, Your Honor.
Oh, we'll need to have a hearing on that, and the person who has the no contact order, they'll need to be present.
It's an 8-year-old child.
Oh, yeah, I'll take testimony and you just have it set and I'll hear it.
Okay, Judge.
All right, thank you.
Thank you.
Barbara Hall,
Good morning, Judge.
good morning.
We're asking for a reset. This is the first time we met. There's an MTR. We have an offer. He was in Medina County. He just got transferred.
Yes, I see that he was in Medina County. How much time are you requesting?
About 3 weeks or so, Judge.
Right. Norma? And we'll set it for contested. If it's not going to be a contested, let probation know at least a week in advance. Ms. Ferguson, I need a 3-week reset.
Yes, ma'am. May 21st.
What? Hold on. Let's see, let me double check here that I could get May the 21st. The judge asked me a question. I have to be able to, if I can do that, okay? So let me get that done real quick. And then, let's see, May the 21st, I will be here.
All right. It'll be set for a contested hearing. Ms. Abrams? On Carvajal, it's May 21st for a contested. Defense counsel will let you know a week in advance.
Is there any way I could do the May the 28th? I have nothing that day. I have a public intoxication trials administered. I don't want to be late. And if I don't show up there, then is there any?
You can do that first and come here after.
I'd rather do the 28th, possible.
I understand what you're saying, but the reason why they gave me this date is because that's where they have an opening in the docket.
Yeah, I have a better opening on my docket.
Well, I can do it sooner than that. I'm sure there's a date sooner that's open.
Well, unfortunately, I have little dots on everything, on every day.
Okay. All right, we'll see you back on the 21st. I'll make a notation that you will be late.
Thank you, Judge.
All right, thank you. Who's next?
Layla Vasquez, page 43 down.
Layla Vasquez.
Morning, Judge.
Good morning. How's it going?
It's going well.
All right. So what is happening with your case? Do you have all discovery?
I don't know, Judge. This is our first setting. Ms. Vasquez has 4 cases. I think one is family violence and 3 other cases are CTD.
All right. Well, what I'll do, because I realized that there were other motions that were heard, and so this is her first time on the docket here because of other issues with the magistrate's court. So I'm going to set this for discovery in 30 days. I need a discovery date, 30 days.
May 28th.
All right, May 28th. Once you sign the reset form, you'll be excused, okay?
Thank you.
All right, and keep doing what you need to do, all right?
Okay, thank you.
You're welcome. Hi.
Hi, so we're about to call chambers, correct?
Yes.
So I don't know if you remember this case, but last time we were here,
Ms. Chambers.
this is a case about a missing wedding ring.
Yes.
And there was a defendant who supposedly arrested with the wedding ring, went to Carnes, I went to Bear, was there for about 10 days. Then the marshals moved him to Carnes. So last time we were here, I was going to try and find the ring. So I got in contact with the Carnes Sheriff Department. They went over to the Carnes detention center and got the manifest of that defendant's items when he was transferred. And all he had on him was a t-shirt and shorts and shoes. So his wallet, his keys, his cell phone, whatever his jewelry was, is all likely still in Bexar County. I have tried multiple times to get in contact with the property department, but the phone just sort of rings and rings, or I get put on hold. The sister of that defendant has attempted to go get the property, but well, first of all, who knows if we could get it back if she did, but she doesn't have an ID to pick up the property. So
all you have to do is file a motion and have that defendant brought over and have the people at the Bexar County Jail, if that's the location of the ring, have them to bring the property with him and they will bring the property.
So, but what case would if I filed a motion to this case, they would go get him in Carnes?
Well, you're saying that he has property here in Bexar County. Isn't it shocking that they didn't transfer his property with Carnes? Is he just in Carnes because there's no room at the jail?
No, he has a federal charge. He was taken over.
Yeah, they should have brought his property with him. Does somebody want to pick up the phone and call Bear County Property and ask them?
I've been calling them. I cannot get through. I don't know if there's an individual that I could call, but like the main number, it's just not.
Does anybody have any objection to the court calling?
No.
All right, so give me this is going to come back this afternoon. Give me the case number, write down the case number of the person whose property is in the property room.
Okay.
Thank you. And y'all will be back at 2. Who's here on Daniel Chapa?
I'm present, Your Honor.
And then after that, it's going to be, there are 2 cases with Chapa. All right, are you ready to proceed?
We are, Judge.
All right, if you come forward. All right, court is calling 2024 CR 0270 and 2024 CR 00769. I'm sorry, 2024 CR 007969, State versus Daniel Chapa. Can I have parties announced?
Michael DeLeon for Mr. Chapa.
And are you Mr. Chapa?
Yes, ma'am.
And each of these cause numbers, did you review the motion to revoke community supervision and the First Amendment motion to revoke community supervision? With your attorney, did you understand it?
Yes.
And the cause number 2024 CR 007969, are you the same Daniel Chapa who was placed on probation for 8 years on October 11, 2024 for the offense of stalking?
Yes.
And in cause number 2024 CR 0270, are you the same Daniel Chapa who was placed on community supervision for assault, bodily injury, family member on September 10th, 2024 for a term of 2 years? Is that you?
Yes.
All right, state.
Your Honor, it will be proceeding on the first amended motion clause. And so I'll read the violation is the same violation of condition number 1. Going or about the 9th day of February 2026 in Bear County, Texas. The defendant Daniel O'Hara Chapa committed the offense of evading arrest, detention, in violation of condition number 1.
And each cause number to that, how do you plead, true or not true?
True.
And then violation of condition number 4 in Bear County, Texas, the defendant Daniel O'Hara Chapa did then and there fails to report to the supervision officer as directed in the months of June, July, August, September, October, November, December 2025 in violation of condition number 4.
To that, and each motion, how do you plead, true or not true?
True.
And we will waive and abandon your Honor.
No
Any
objection.
objections?
No objection.
Did you understand by pleading true to 1 and 4 and the cause number ending in 70, the court could find it true, grant the motion, and sentence you up to 1 year in the Bear County Jail? And by pleading true to violations 1 and 4 and the cause number ending in 69, the court could grant the motion and sentence you up to 10 years in the prison. Did you understand that? Knowing that, do you still wish to plead to violations 1 and 4 in each cause number? All right, then in each cause number, the court will find violations of 1 and 4 true. Is there a proposed agreement?
There is, Your Honor, cause number ending in 69, the agreement for the court to consider is granted the state's motion, revoking the defendant's community supervision and reforming the judgment to reflect a prison sentence of 7 years. And then regarding the cause number ending in 70, the agreement for the court's consideration is to grant the state's motion, revoke the community supervision, and sentence to 1 year in Bear County Jail to run concurrent, Judge. And then the state will be taking into consideration clause number 2026 AL 003542, as well as clause number.
Sure.
(2026) PC 004079.
All right, is that your proposed agreement,
That
counsel?
is our agreement, Judge. We'd ask the court follow that agreement. Additionally, we'd ask for any back time that he's had on these cases
All right.
credited.
Are you asking the court to follow those agreements? And each cause number, are you waiving your right to appeal?
Yes, yes, Dr. Musai.
And the cause number 2024 CR 0270. The court, as previously stated, is finding 1 and 4 true. The court will grant the motion, sentence you to 1 year in the Bexar County Jail. This will run concurrent with 2024 CR 007969. Taking consideration 2026 AL 003542, 2026 CC 004074. There's an affirmative finding of family violence. There's to be no contact with Veronica Medellin. And there's to be no unsupervised contact with minors. And no residing in households with minors. And cause number 2024 CR 007969. And I'm sorry, in that previous cause number, the court will give, of course, credit for any time served. And in the next cause number, the court will follow your agreement. The court will sentence you to 7 years in the prison. This will run concurrent with 2024 CR 0270. There's to be no contact with Elaine Rodriguez. Credit for any time served. No unsupervised contact with minors. And no residing in households with minors. And each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes.
And each of the cause numbers, because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? You're welcome.
Good luck to you.
Yes, Your Honor.
Yes, Your Honor.
All right, so this is what the court will do. The court is going to deny the motion. Alter and amend conditions to include the following. The court is going to order the Genesis program. And there's to be an evaluation in custody and probation. That evaluation in custody, what is it for? All right, so there's going to be a mental health evaluation in custody. And probation, you said that will take 2 weeks?
Yes, Judge, I'll ask that it expedited.
All right, so Ms. Ferguson, can you give me a court date that's in 16 days, please?
Okay. I can do the 19th, Judge.
All right, so that date for May 19th is just to make sure that all of the evaluations are done. All right, so after the evaluation, the court is going to order that he is released from custody. There is going to be partial GPS, waive fees. GPS will be until further notice and is partial for all medical appointments and attendance of church. And with regards to attendance of church, you all will need to give the court the hours of that. I mean, if it's a Baptist church, I'm Baptist, you know, we're not doing Monday, Wednesday, Friday, and Thursday, so, and Sunday. Veronica, you know about that. I mean, church can go from 9 a.m. to 6 p.m. And then if it's revival, it goes into the night. So, all right. So all medical appointments and attendance of church, and y'all will give the time. And he is to reside with his mother. And what is his mom's name?
Michelle Coleman.
MCHELLE.
Okay. Thank you. And Ms. Coleman will provide the address. All right. And probation, is there anything else that I'm forgetting?
No, Judge.
All right. So they're gonna give you a reset form for for May 19th, okay? And I have it on here just in case something happens with the evaluations. That way we won't lose track of you, all right? All right, good luck to you. Welcome. Are the parties here on Quinette Perry? All right, are you ready?
Yes, sir.
All right, if you come forward, please. Probation, this is an application. Court is calling 2025 CR 005793 State versus Quinette Perry. Can I have parties announced?
Lauren Espinoza for the state. Tiffany Seattle from Ms. Perry.
And is your first name Quinette?
Yes, ma'am.
All right, thank you. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Perry, did you review the application for community supervision with your attorney? Did you understand it?
Yes, ma'am.
And sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
I believe we're waiving the punishment enhancement.
Any objection?
No objection, Your Honor.
Ms. Perry, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with theft of property, $2,500, less than $2,500 with 2 or more previous convictions. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she was.
Ms. Perry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 1 year in the state jail facility. There's an $800 fine, and the state is recommending community supervision. Did you understand that to be the plea? Defense state.
Yes, Judge. Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Amelia Gomez or Angelica Gonzalez, and the anti-theft course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State offer State's Exhibit 1 in all attachments. No objection, Your Honor.
All right, state in this case, there's no restitution.
No, Judge.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We're waiving PSI.
All right. You want to explain to me, or maybe your counsel can explain to me, why are you doing this?
Your Honor, we believe, just based on the facts of this case, that's best to just go ahead and agree to the plea offer that the state gave us. As far as sentencing goes and accepting these terms, we think they're the most favorable to her. The last time she has been in trouble was in 2017.
Yes.
And she hasn't been in trouble since. She's been clean. She's been trying to take care of her kids. She's a full-time caretaker for her son, who has also mental health and behavioral issues. Her daughter has since learned her lesson. Her daughter is now an adult. She's no longer a juvenile.
But has she really learned her lesson? Because what I'm reading in the stipulation is she's the one who ended up pawning the bracelet.
Yes, Judge, at the direction of her daughter, Precious, but Precious has since.
Well, wait a minute. So during this time, how old was Precious?
I can speak. When this incident took place, she was 16. Her and the other little girl were minors.
Okay, so Precious is 16 and Precious
Now
told you
she's
to.
18.
Yeah, no. But at this time when Precious was.
Have an ID upon it. She was gonna give it back, but when the ISD kept pressuring her, she shut down. She didn't give it back.
And so she gave it to you and told you to pawn it. Okay, that doesn't make any sense to
To
me.
get her money back from the little girl that stole from her.
I don't know what's happening in this world. Because no. Here's the thing. As a parent, if this other minor stole $20 from your daughter over the summertime, and what I'm reading in the stipulations, she didn't steal it. Another one of her relatives stole it, who's probably not a good parent or a good relative. And then your daughter decides to steal a Pandora bracelet from this little girl, which probably costs more than $20. And then I'm reading in the stipulations where they're asking you to get it back from your daughter. And you're like, oh, my daughter needs to calm down first. Do you even see how that my daughter stole somebody's bracelet? But you know what? I can't approach her yet. She needs to calm down. And then she doesn't calm down. And they're like, hey, you need to turn this bracelet over now. You say, and then you tell them, well, you're not getting it. How about them apples? And then you're telling me your 16-year-old daughter comes to you and says, this is the bracelet. I need you to pawn it. And you being the adult in this situation is listening to your 16-year-old daughter to go pawn a bracelet that you know is stolen. Do you see?
It was 2 years ago. And like I said, when I made them choices back then, it ain't nothing like that. I made a wrong choice back then when I shouldn't have, like I told her. And like I was telling the other mom, me and the other mom, we got into it, we're doing it over. We should have gave her money back. My daughter shouldn't have did that.
Well, according to the stipulations, the minor is not even the one who stole $20 from your daughter. It's some other relative.
The minor who did it.
I'm just telling you what's in the stipulations, which y'all stipulated to.
Yes, ma'am.
And even if she did it, I don't know why you would think 2 years ago that it would be okay to take this Pandora bracelet and pawn it. And how much money did you get for the Pandora bracelet?
$40 that she took from her.
No, according to this, it was only $20 that a relative took.
The girl stole it from my house and my daughter's room. That's what I was at. This, when my daughter took her bracelet, it was at school. When I was talking to the mom and the stepdad about this, they didn't want to hear nothing about it.
Your Honor, I believe at the time she thought she was writing her daughter, putting her daughter in the right and making her, even with the money now in hindsight, wasn't the best parenting decision. It was in the heat of the moment. She's since learned that probably think about things before doing something so reckless. And she understands that now. We've had several long talks about this.
That's why Precious, her ass is getting a job. She's old enough now, she got something like that.
See, we're still in the same position. Does Precious have a job?
No, she just got her ID just recently and now she's looking for a job. She has a job interview after this.
Yeah. There's going to be an $800 fine, 1 year in the state jail facility, suspended and probated for 3 years, 200 hours of community service restitution, no contact with Amelia Gomez or Angelica Gonzalez. And that's Gonzalez with a Z.
I believe so, Your Honor.
Oh, no, I'm saying that it's in the anti-theft course. Field visits 1 time per month for 8 months. Proof of employment within 30 days. No employment as a home health care provider or with minors. TAP evaluation out of custody, follow recommendations, and the MRT. And no possession of firearms. And what are the ages of the children in your home?
28, 19, 18.
Okay. No unsupervised contact with minors. Probation, is there anything else?
UA, reporting.
Thank you. Regular random UAs. Regular reporting by Zoom or in person. Anything else?
No.
No, Judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck.
Your Honor, if I may, the plea bargain was during the stage of felony suspended for 2 years.
No, this is what I always have to remind people. Anything below the line is not a part of your plea bargain agreement, and you're not allowed to enter into an agreement for a length of probation time or certain conditions of probation. The only thing you're allowed to agree to is we have an agreement that she's to receive probation or a fine. But as far as conditions and length, you're not allowed to agree to that. All right, thank you.
Maybe excuse?
Yes.
Thank you, Judge. Have a happy Mother's Day.
Oh, thank you. Calling 2025 CR 015820 State versus Danny Cantu. Can I have parties announced for the record?
Lawrence Vanessa for the state.
Joanne DeHoyos for the defendant who is present.
And are you Mr. Cantu?
Yes, ma'am.
All right, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
And did you review that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Junior proceeding on the lesser included offense of attempted possession of a controlled substance, PG2 less than 1 gram.
Any objection?
None, Your Honor.
Oh, that's yours. Thank you. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the state is proceeding on the less included offense of attempted possession of a controlled substance. Penalty group 2, less than 1 gram. That's a class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense. They're asking that your punishment be assessed at 1 year in the Bexar County Jail, a $1,000 fine, and they're recommending community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense and state?
Yes, Your Honor.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours of community service restitution, and the DOEP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not, I'm sorry, the lesser included offense. How do you plead? Guilty, not guilty, or no contest?
No contents.
State any evidence?
Yes, Your Honor, State Offer State Exhibit 1 and all attachments.
Got reviewed the same, signed it, and we have no objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we could.
Anything you wish to say on behalf of your client?
Just to let you know that he's checked with his boss, this conviction be satisfied, that he's going to keep his job, so he thanks the community for this opportunity.
All right. So the people who were in the vehicle with you, what are their relationship to you?
My girlfriend.
Okay. And if you're drug tested today, what are the results going to be?
Not really too sure. I might come out, I might be good, honestly.
When's the last time you used anything?
Like a little bit over 3 weeks.
All right. While you're on probation, you know you're not allowed to use. All right. And what do you do for a living?
I do construction.
Okay. And are you still together?
Yes.
All right. This is what the court is going to do. The court is going to sentence you to 1 year in the Bexar County Jail, suspended and probated for 1 year. And let me just tell you, one of the reasons why I'm doing that, and your attorney will tell you this, it is so rare for people to accept responsibility of narcotics in the vehicle. Usually they have their girlfriend or their wife accept it, or either they say, that's not mine. So in the stipulations, I think you had already started forming, you were wrong for this because you said everything in the vehicle is mine. So it's going to be suspended and probated for 1 year. There's going to be regular reporting by Zoom or in person. There'll be regular UAs, random UAs. Make sure he's tested for levels. Is the only thing you're going to be positive for marijuana?
Yes.
All right. Those levels need to start going down. And if there's a reason you're using that that's related to anxiety or some sort of mental health, let probation know so they can give you the help you need. Okay.
Yes, ma'am.
Field visits 1 time per month for 2 months. There's going to be 200 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, 100 hours will be deducted.
Thank you.
The remaining 100 hours will be deducted upon completion of the DOEP course, which I'm ordering. There's to be a TAP evaluation out of custody. Follow recommendations, with the exception if they recommend inpatient treatment, we'll start with outpatient treatment. Let me see. Probation. Is there anything else? Oh, thank you. Proof of employment within 45 days, no employment as a home health care provider with minors. And I'm sorry, I forgot, $1,000 fine, and that will be probated.
Thank you.
Anything else?
Thank you for this opportunity. My client is fully aware of his responsibilities now.
All right, thank you. Is there anything else you need help with?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes. Yes, ma'am.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. Stay on the straight and narrow.
Yes, ma'am.
All right, so this is supposed to be a contested?
No, we have an agreement, Judge.
All right. All right, court is calling 2024 CR 007568 State versus Chaz Reed. Can I have parties announced?
Rick Pena for the state of Texas.
Donald Wilson for the defense.
All right, and are you Mr. Reed?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Chaz Reed who was placed on probation in 2024 CR 007568 for a violation of registration on September 26, 2024 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violation of condition number one. On or about the 22nd day of January, 2026, in Bear County, Texas, the defendant, Chaz Jabbar Reed, committed the offense of failed to comply sex offender duty to register life annual in violation of condition number one.
How do you plead to that? True or not true?
Let's take away the other violation, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion and sentence you up to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number one?
Yes.
Court will find violation of condition number one true. Is there a proposed agreement?
There is, Your Honor, that is to grant the state's motion. Reform, thank you. Conditions, sentence the defendant or revoke the defendant's probation or sentencing to 3 years TDC.
Is that the agreement?
That's the agreement.
Mr. Reed, are you asking the court to follow that agreement? Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement. The court will revoke, sentence you to 3 years in the prison, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes, ma'am.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.
And Your Honor.
Yes,
Before you leave, I need to present this to you.
yes. Are you taking something in consideration?
Yes, Your Honor.
All right, what's being taken in consideration for the record?
The new.
Clause number?
2026 EF 06300.
All right.
Well, Judge, I think if the 299 BF number is being discussed.
Yes,
as well.
yes, Your Honor.
All right, and what is the other number? For the record?
2026 PF 06299.
06299?
Yes, Your Honor.
All right. Thank you. Theodore Garcia. All right, Mr. Garcia, court is at 9. Good afternoon. Court's at 9 a.m. You got to be here at 9, okay?
Your Honor, I'm so sorry, Your Honor.
No problem. All right, today was supposed to be plea deadline date.
Judge, I'm standing in for Mr. Acevedo. I conferred with him. He indicated that he does have all of the discovery. I believe that they conferred with the state, and what he's asking is a referral for vet court.
All right, so I can tell you this with regards to Veterans Court. One, there can be a referral there. However, they don't do pretrial diversion, so he would still have to be on probation here. And Ms. Abrams?
Yes, Judge. I do want to make the court aware that we did speak to Veterans Treatment Court this morning in regards to this case. He was a participant in Veterans Treatment Court previously. And they're just going to look at it very, very closely. They're going to have to seriously consider accepting him back. But they would take the referral.
All right, and when are they going to have a chance to review? Do they know?
Not sure, Judge. I'll have to get the referral to them.
All right, so this is what we're going to do. This is going to be recalled back on May 7th. They're going to send over the referral. You'll need to be here on May 7th at 9 a.m. You understand?
Yes, Your Honor.
And then we'll see when they will have the referral done. All right. Thank you. Once you sign the reset form, you're excused, okay?
Yes, Your Honor.
All right, you're welcome.
Thank you, Judge.
Who else?
Jose Moreno, he's on page 6 at the bottom.
Jose Moreno.
Present.
All right. So in this case, there was an offer tendered. There was supposed to be some sort of disposition on April 15th in 2025 CC 016699.
Well, I know there was an offer in the file that if you put on that case that they were going to dismiss this case. I was speaking to Mr. Martinez, who's his attorney on the DWI by text. He says he's out of town. I don't know what the details are. It shows that case was set for today, but he's out of town. There's no new setting as, you know, as if you got it reset. Mr. Martinez told me that his staff is contacting County Court Fee 14 about getting a date for him to go in and plead that DWI.
And that's our intention, Judge, is that if the plea is done in the misdemeanor, then this case will be dismissed.
So is it on the docket and what court is this?
County Court 14, Judge.
So is it on the docket in County Court 14 today?
It was set today, yes.
All right, so why hasn't that been taken care of if that's supposed to?
Like we haven't received word that a plea was taken in County Court 14.
Well, and I don't think it has, unless Mr. Martinez left later in the day. He's telling me he's out of town. I don't know where.
Is there only one prosecutor in that county court at law?
I know, Judge. In some of the misdemeanor courts, yes, there is only one.
So that court, what everybody is telling me is that court is not having court because they don't have a prosecutor.
Unknown, Judge.
All right, Norma, can you see if county court at law number 14 is having court today? Or if they had court?
That's what he's telling me he's out of town.
attorney is not
So it's not that.
Oh, I thought he was saying the state, yeah.
Okay.
Oh, no, Judge.
It's like, what, there's only one prosecutor?
Yeah.
All right, and who is the defense attorney? Martinez who?
Lucas, yes.
All right, so when is he gonna be back?
Good question. Can I call him, Judge?
Yes. You were scaring me there for a moment, or raising concerns.
Sorry about that.
I was like,
Answering your questions to the best of my ability.
it's like, yeah, sometimes we only have one.
Hey, Judge wants to know when you're gonna be back.
I was on my own in County Court 15 for a year.
Oh, wow.
You're getting back Tuesday? So you're back in the office Wednesday? Okay, he's back in his office on Wednesday, Judge.
All right, Norma, recall this for, well, let him know he needs to set that. Norma, recall this for May 7th.
Yes, ma'am.
He's recalling it for a week from today. He wants you to see about getting the County Court 14 plea done before then, I guess.
And this is the final plea deadline date.
One or the other.
Once you sign the reset form, you're excused. All right, thank you.
All right, no,
Thank you, Judge.
You're welcome.
all right, thanks.
And Mr. Behrens, are you ready to proceed on Bustos?
There's an offer in the file. That's all I know, Judge. I haven't been, this is third time she hasn't been here.
Oh, we're
I
gonna take
think
that
last
up
week
now.
he showed up 2 or 3 o'clock in the afternoon after I was long gone and
Yeah. All right, the court is gonna call 2026 CR 002593 State versus Daniela Bustos. Can I have parties announced for the state
Brandon Prater for the state.
defense?
Robert Behrens.
All right, this hearing was scheduled at 9 a.m. It is now 2:28 p.m. The defendant has not made an appearance. Defense, have you had any contact with Daniela Bustos?
I have not, Judge.
All right, Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. Negative contact.
State?
Judge will be requesting a bond forfeiture.
All right, the court will issue a judge's warrant remand without bond. And state on Arnold Pena, Arnold Pena, how many witnesses do you have?
We have 2 witnesses, Judge.
All right, let's take it up. Mr. Bach, are you ready? Oh. Court is calling 2025 CR 010725 State versus Arnold Pena. Can I have parties announced for the record for the
Brandon-
state
Brandon Prater for the state.
defense? And you're Mr. Pena?
Yeah.
All right. You entered a plea. According to your plea bargain agreement, punishment is to be assessed at a cap of 25 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication. Have both parties had a chance to review the PSI report?
We have.
We have, Judge.
Any objections?
None from the state.
There are some factual inaccuracies.
Yes.
One of the greatest perhaps is that it lists him as having no dependents, so he has 2 biological children and some stepchildren as well that he takes care of. And so it's different than it appears on the first page of the PSI.
Okay. All right. State, any witnesses?
Judge, we have 2 witnesses.
All right, call your first witness.
Judge, the state calls Miss Lisa Chapa.
Mr. Pena, you're back against the counter.
Oh, thank you. Would you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record, please.
Lisa Chop.
All right, state, you may proceed.
I think, Ms. Chapa, how are you related to Jalen?
I am his mother.
Okay, and can you tell me, after the shooting, what was Jalen's condition?
He was in the hospital for about maybe 4 to 5 days. He had a 5.5 hour surgery that day.
Okay, was that the only surgery he had, or did he have to have multiple surgeries?
He's had a total of 5 surgeries, and he'll have another surgery when he turns 21 for major reconstructive of the upper.
I'll take that up.
jaw.
Okay, so he's gonna have to have 6 surgeries overall to repair the damage? Or more?
Overall 6 surgeries, but he'll also have to have a couple of implants and some more other dental work done.
Okay. Lisa, I'm gonna show you what's been labeled State Exhibit 2, 3, and 4. Can you tell me what these are? These photos.
I did.
Okay, and looking at them, do they look like they've been edited? They're clear and accurate representation of what you saw that day?
They're exactly what I turned over.
Okay. Judge, the state would like to admit State Exhibit 2, 3, and 4 into evidence. Pending any objection?
No objection.
All right.
Permission to publish?
Yes. State's exhibits 2, 3, and 4 are admitted without objection.
Lisa, without going into, only going on what you know, not on what you've been told,
Mhm.
how has this affected Jalen mentally?
He has dealt with depression, anger. He's had nightmares. Every time he goes into like a surgical procedure, he has severe anxiety. He thinks he's not going to make it out of the procedure. He worries if he's going to die.
What was he like before this?
He's a very charismatic, carefree child, or was. He didn't know an enemy. He didn't have enemies. To him, everybody was his friend. There wasn't a such thing as bad people. He could go, and this is gonna sound horrible, he could go to a funeral and not know anybody and then come out and everybody was his friend.
Very gregarious, very friendly.
Very friendly, very charismatic, go-getter.
Is he like that now?
No, he's more reserved.
Yeah. How old was he when the shooting happened?
He was 17.
17? Okay, so it wasn't 18 yet.
No, he was not.
He was still legally a child.
Yes.
Okay. I'm gonna ask you. So the offer right now is what's called a cap offer. It means it's a cap of 25 opposed. That means that judge can sentence all the way up to 25 years.
Yes.
She can also sentence what's called deferred adjudication, which means that Mr. Pena would be on supervision, but he would be out in the community.
Yes.
I'm gonna ask you, in your opinion, because the complainant witness is your son, what would be the appropriate punishment for what Mr. Pena did to Jalen?
That invades the province of the court.
Right, that'll be sustained.
Thank you, Lisa. We'll pass the witness.
He was 17 at the time,
Yes, sir, he was.
and as I understand it, he had been downtown partying with his girlfriend all night and then went from downtown to her house. And then at 5:30 in the morning, he was finally coming, home back to you, or where was he going at 5:30?
He was coming back home.
So am I correct? He'd been downtown partying that night and then,
He left the house. He was typical 17-year-old who thinks that he knows everything and doesn't have to listen to the rules that he had in home. He picked up his girlfriend. They were hanging out. I don't know where they were hanging out at. I know that at one point he came home. I told him he needed to take her back home because I didn't approve. And he left. I was assuming to drop her off at home. And that's all I know. And then he was on his way home at the time he was shot by the defendant.
is the location that where this allegedly occurred somewhere between his girlfriend's house and your house?
My house.
It's close to your house?
Yes.
And the downtown, I wasn't trying to put words in your mouth. I got the partying downtown was stuff he said in the PSI. So that's where, in the police report. So that's where I got that from, just in case you were thinking I was not being straight with you. So your testimony is he had been out all night, came home. What time did he come home to your house with his girlfriend?
Probably about 10:30 or 11, and I told him he needed to go home because it was not appropriate. And he needed to take his girlfriend home. And he said he was, and he left.
And what time? And
It was about probably 11:30.
so from 11 to 5:30, where was he? If you know,
I do not know, sir.
did you ever ask, inquire?
No, because when all this happened, that was not my top priority.
Okay. And you're aware that perhaps his driving also played a part in this?
Objection, Judge, beyond the witness's personal knowledge.
If she's aware.
All right,
I
that'll
am
be
not-
overruled.
Okay, that's all I have.
All right, thank you so much. Call your next witness.
Judge, the state will call Mr. Jalen Chapa.
Hello, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Jalen Chapa.
All right, you may proceed.
Thank you, Judge. Jalen, how old are you right now?
I'm 18.
Okay, and how old are you on the day of the shooting?
17.
All right, so walk us through that day, man. How did it start? What happened?
Okay, so at the beginning of the night, I wasn't listening to my mom. I had left to go get my girlfriend, and I picked her up, brought her back to my house. My mom didn't want her there, so I left. And when I left, I went downtown. I was not partying. I didn't have any substances in me, nothing. I was downtown for maybe 2-3 hours, and then I took my girlfriend back home. She doesn't live over here, so I took her back home. And taking her back home, that's about an hour and a half drive. So I took her home, and then I headed back to San Antonio, and I had got on Highway 90. And when I got on Highway 90, I had driven down Highway 90 about a mile. A mile after Highway 90, the defendant, he came up driving real fast. And on the side of me, there was another 18-wheeler. There was an 18-wheeler. On the other side, there was another 18-wheeler. I was in the right lane. I was in the right lane, and when I was in the right lane, he tried pushing me off the road off to the side so we could get past.
And when you say he, like pronouns are like, let's not use pronouns. Who was he?
The defendant.
Okay, Arnold Pena?
Arnold Pena.
Let's use Arnold Pena. So Arnold Pena was trying to push you off to
He was
the
trying to
median?
push me off to the median so we could get around.
Okay.
I didn't have a chance. I wasn't gonna go onto the median because I wasn't gonna ruin my car. So I kept driving.
Was it,
and
what kind of median was it? Was it like a concrete median or
It
a
was
grass median?
it was a concrete median that turned into a grass median.
Okay, all right, keep going.
So I was driving. I didn't let him over because there was no way to let him over. At that point in time, I did roll down my window and I put my hands out the window because I didn't know what was going on. I had never encountered anything like this ever.
When you put your hands out the window, what kind of gesture was it like?
I was
What's going on?
And right after that, a couple of seconds later, I'm looking at a gun. He goes onto his lap, he pulls out a gun, he's pointing at me. So after that, I speed up. I get around traffic. I go down Highway 90, and at that point, I thought I had lost him. So I was going down Highway 90. I look in my rearview mirror. Somebody's speeding up behind me. I look over. It's him. So I just let him pass me. He gets in front of me. I'm like, okay. So at that point in time, I tried taking a picture of his license plate. I couldn't because I was driving. So I got his license plate number. I texted it to my girlfriend. After I texted it to my girlfriend, I missed my exit. So I had just tried going by, but I was recording just in case anything happened. And as soon as I get next to him, I get shot.
Okay. And did you have your phone in your hand when you were shot?
I did, yes, sir.
Do you happen to have the phone that you had that day?
I do, yes, sir.
Can you show it to the court?
I don't have it on me. May I grab it?
Yeah, go grab it.
The phone that I had.
Okay. For purpose of the record, can you describe the color, the look of it, shape?
It's a light blue phone. Has a clear phone case. I mean,
And when you were holding it up, Were you recording on opinion?
I was recording, yes, sir, I was recording.
Can you demonstrate to the court how you were holding
I
it?
had my phone out the window like this.
Okay, so,
And
so it was with the light side facing outward like
yes,
that?
sir, it was like that.
Okay. So. Did you ever honk at Arnold Pena's vehicle?
I never once honked.
Okay, and why is that?
My horn on my car it doesn't work right.
Okay.
It doesn't work right. So for me to be able to honk, I have to go full force honk.
Okay.
And I don't honk at all, if I'm being completely honest with you. It's just I don't honk.
Okay. When you at any time when he first flashed the gun at you to when he was back alongside you, were you driving aggressively towards him?
No, sir.
Were you swerving into him?
No, sir.
Were you trying to goad or provoke him into something?
No, sir.
Okay. Where'd you get shot at?
In my face.
Can you show to the court where the entry wound was?
It was right here.
Okay. So that's about, if I may, it's about 4 inches from your forehead. Is that about right?
Yes, sir.
Okay. After you got shot, describe what you saw. What happened?
Okay, so right after I got shot, everything went black. So I didn't know what was going on. I was out of it. I came back to it, but I couldn't see. Like my vision was completely blurry. I couldn't see anything. And it took me a couple of seconds to come back because everything went black. And when it came back, it looked staticky. So I come back and I realized I had got shot. And when I had realized I got shot, I freaked out. I really did. I started crying, I freaked out. And when I had opened my mouth, my whole jaw, like the whole top of my mouth had fallen in my mouth. So I was like, oh, okay. And when I looked over, Arnold Pena was right there next to my car. And
so you saw him after you got shot?
I saw him. He was right next to me. Yes, sir.
What did he do?
I had asked, I started crying. I didn't know what to do. So I had asked him, I was like, bro, you shot me. Like, can you please help me? And
what did he do?
He just drove off. He looked at me and drove off.
After you asked him to help you?
Yes, sir. He sped off.
What happened next, man, when he drove off?
I pulled over. I got out of my car. I collapsed on the highway. I forgot to put my car in park, so my car went off the highway and it smacked the wall. And when it hit the wall, it turned around and ended up in grass. And after that, I had fallen again. And so a group of it was a garbage truck, they had pulled over to help me. And at that point, I was desperate. So I got up and I ran to them. I was trying to get help. I didn't know what to do. I was close to home, you know what I mean? I got my mom and I got my little brother at home.
Yeah.
So I was trying to get help. Like I had no way to get help at all. So I ran up to them. They tried helping me, and as soon as I ran up to them, the sheriff showed up.
Okay, what happened next?
When the sheriff showed up, they called the ambulance. I asked them for water. They said no, I couldn't because of the condition I was in. So they had
Why
me.
couldn't you drink the water?
My mouth, it collapsed.
Okay.
Everything was coming out of my face because it went in and it came out. So I was bleeding out from my whole face. I couldn't talk right. Like I was able to tell the police officers like where I lived, my mom's name, my name, that kind of thing. And after that, I mean, I don't really remember much. I mean, I remember getting in the ambulance, and after I got in the ambulance, I didn't remember much other than I woke up at the hospital. When I woke up at the hospital, I had already been sitting there for 2 hours, I guess, and I got to a point where I started throwing up blood.
Yeah.
I mean, they rushed me into surgery. They had to pull a bunch of my teeth because I lost a lot of teeth. They did that, and then I went into surgery. I didn't wake up till like a day later. They had put me in a coma because I had a really harsh surgery. I was in surgery for about 5 to 6 hours.
Okay.
And then right after that surgery, I think 2 weeks later, I had to go to get another surgery. And then after that, surgeries just kept coming and coming and coming.
Yeah. How many surgeries have you had to have?
Recently, I think I had five or six, but I had a surgery to get my jaw fixed because my jaw was shattered. So they had to fix my jaw. So my mouth was wired shut for a month. After that surgery, I had to go get a surgery for the roof of my mouth because the roof of my mouth wasn't there.
Mm-hmm.
So I had to get that fixed because there was a big hole in it.
So basically had to have your whole mouth reconstructed.
Oh, and it's still not fixed. I may look fine, but I'm not.
It's still going.
It's still going. I've still got more surgeries ahead of me. I mean, they told me at my last visit that the hole in my mouth may not be closed, and it's causing me to have sinus issues.
Yeah.
So they said that's a possibility. Then I have to get implants, and when I'm 21, I do have to get another surgery for my mouth again. They don't want to do it now because of how many surgeries I've been through already.
Yeah.
And because it's a pretty big procedure, so they want to wait till I'm 21.
Okay.
Yes, sir.
Let me ask you, man, that scar right there, it's still pretty fresh. Do you think that's ever gonna heal?
No.
It's gonna be there forever?
Yeah, the doctors, yes, sir. The doctors already told me that it's gonna be there. It's not gonna go anywhere.
Okay. To be honest with you, man, how's this affected you mentally, man? Are you sleeping? Have you been to therapy?
I mean, I went to therapy for a little bit.
Yeah.
But honestly, I'm not the therapy type of person. So I can't go and talk about my feelings. I'd rather just hold it in. And when it gets to me, it gets to me. I let it all out at once. And it's not the healthiest thing, but that's what I do. And mentally, I'm all over the place still to this day. I mean, there's a lot of things that have gone through my mind, and it's just, there's times where I do think, like, I don't want to sound brutal, but there's times I do think that bullet should have taken my life. Because all the stuff that I've had to go through, I don't want to go through, and I don't think anyone should have to go through.
Yeah.
So there's times where I do think to myself, and I'm like, I'd rather be dead than be dealing with all of this.
Well, this isn't a question of a statement, but like, go to therapy, man, and don't make a permanent choice for a temporary solution, all right?
Yes, sir.
So it sounds like you're gonna be recovering from this for a while
Yes, sir.
and possibly never recover fully.
Yes,
And
sir.
how old are you again?
I'm 18. I just turned 18 in October.
And you got your whole life ahead of you, right?
Yes, sir.
Judge, I'll pass the witness.
Defense.
So let's start, you're not a therapy kind of guy. You hold it in and then it just comes out?
Yeah.
You just lose your temper or something?
I don't lose my temper. I just cry.
Okay. Now that night, you said you were at your mom's house with your girlfriend.
Yes, sir.
And then where did your mom live? Don't give me an address, but what part of town? How far away from downtown did she live at the time?
15 minutes.
15 minutes. And then you left her house and y'all went downtown.
I went downtown. Yes, sir.
And in the police report or whatever you said, we went and partied downtown. So what'd y'all do? I mean, you
I
can't
drove
get into a club, you can't get to a
I
bar
drove around downtown.
for 3 hours.
Yes, sir.
Y'all never got out of the car. You just saying you drove
I
around?
mean, I got off the car to go to the gas station. That's about it, sir.
Okay. And then you said she lived an hour and a half away. Where did she live?
I'd rather not answer that.
Not the address. What city or what direction?
She lives near Floresville, past Floresville.
Past Floresville. Okay. So you'd been out all night with her,
Yes, sir.
dropped her off, and you're still out, and it's 5:30 in the morning when Mr. Pena is going to work,
Yes, sir.
and you're coming home from a night out,
Yes, sir.
right? Okay. Now, you gave a different version today of what happened to what you told the police and what you told the pretrial of this PSI officer. So you said today, in this version today, that my client got behind you, tried to push you off the road. Did his car strike the back of your car?
Yeah,
Judge, I'm gonna object to that. Under 613 with the prior consistent statement, certain predicate needs to be laid out. Mr. Bunk has not laid that predicate.
All right, that'll be overruled. You can ask the question.
You said he pushed you off, did he strike the back of your car?
He did not.
Or did he just get up close behind you?
He got up close to my rear door.
Okay, and that's when you did you raised your hands?
Yes, sir.
Okay. Now, you said, and at that point, you said you were able to get around him and you drove off thinking you had lost him.
I didn't get around him. I got around the semi-trucks. I sped up so people would sped up. I mean, honestly, I don't want to be staring at a gun. I don't want to be anywhere near a gun.
You got past him and you drove off, right?
Yes, sir.
You told the judge a minute ago, you thought you had gotten away from him, you drove off.
Yes, sir.
Now, in the police report, you say the only reason you passed him was because you couldn't see what he looked like and you wanted to get a picture of him. So you pulled around and you got in front of him and you tried to take a picture of him. That's different from what you said today.
Yes, sir.
So which one actually happened? You got in front of him and slowed down so you could try to take a picture or whatever you were doing with your hands, or you spread off and he somehow caught you?
This was two different events, sir. He pulled a gun on me multiple times.
After you say he pulled the gun from his lap, and you don't know where it came from, right? You didn't see it come from his lap. You're just assuming that's where it came from, right?
Yes, sir.
Okay, so you said today, in this session today, after that happened and you saw the gun, you were able to get around him and you drove off and you thought you had lost him.
Yes, sir.
Okay. Now, in the police reports, you say, when I got around him, I slowed down because I wanted to get a picture of him so I could see what he looked like.
Yes, sir. I slowed down to take a picture of his license plate. Yes, sir.
So when did that happen?
That happened right before I got shot, moments right before I got shot.
So you're saying you sped off and drove off,
Mhm.
but some guy's pulled a gun on you, you've driven off, and then somehow he catches you,
Yes, sir.
and you weren't doing anything.
No, sir.
Okay. And then at some point, you take something out of your lap and stick it out of the window in your hand, right?
Yes, sir.
And it's 5:30 in the morning, so it's dark
The sun was out, sir.
at 5:30?
Yes, sir.
What month did this happen?
It was 6:30 in the morning, sir.
January at 6:30? You're saying it was light?
Yes, sir.
Okay. So you take something out of your lap, hold it out of the window, right?
Yes, sir.
Because at that point you say right before you got shot, you were trying to take a picture of him.
Yes, sir.
So he reacted to what you did. You take something out of your lap, stick it out of the window, and right after you did that is when he shot you. Is that what you're saying, correct?
I had my phone out of the window the whole time.
Well, not the whole time because you drove off and lost him.
Yes, sir.
Okay.
But when I got his license plate,
Now, another thing is you said today is, as far as I know, from having read the reports and the PSIs, this is the first time I've heard about how you stopped and he stopped beside you and y'all talked and then he drove off. That's not in the police reports anywhere.
okay.
Is that something you just remember? Or is that something that didn't really happen? It just sounds better.
No, I didn't mean by he physically stopped. I was on the highway when I woke up. I was still driving, and I looked over and he was right there. That's what I meant.
Okay, so you made it sound like you stopped and he stopped
No,
because
no,
you said, and then he drove off.
Well, he took off. Yes, sir.
Okay, all right. And you're saying this all happened on Highway 90? It didn't start somewhere else and end up on Highway 90? Are you sure?
If I'm being honest with you, I don't know
Please
my
do.
highways like that. But
Okay.
I know the highway that I have to take to get home from my girlfriend, and it was Highway 90.
Okay, so and if that's the case, then this all happened on Highway
Yes, sir.
90. Okay,
Yes, sir.
all right. All right. That's all I have, Judge.
No further, Judge.
All right, thank you.
Thank you, ma'am.
Call your next witness.
Stay resting close.
Defense, any witnesses?
Yes, Judge. I'm going to call my client, Judge.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so I can hear and the court reporter can hear.
Yes, ma'am.
All right, if you state your name for the record.
Arnold Pena.
All right, you may proceed.
Okay, now, Mr. Pena, let's start with you and I have only met recently. I mean, within the last couple of months, is that correct?
Yes,
I
sir.
wasn't your lawyer at the time you entered this plea, right?
Yes, ma'am.
And we, earlier today, we concluded a motion to withdraw your plea and we're at the sentencing as a result of the judge's ruling. Is that correct?
Yes.
Okay. Now, you and I, after that, had a chance to go through what's called the pre-sentence investigation, which is the document I'm holding now. And you and I went through this in its entirety, correct?
Yes, sir.
And that's where you pointed out to me that you actually do have some children.
Yes, sir.
Now, on page 2, it seems to indicate that you've never been arrested for anything in your life prior to today. Is that factually correct?
Yes.
Okay. Now, let's rewind, if we will, to that morning. Do you remember that morning?
Yes, sir.
Okay. So what, were you just coming out from a night partying all night with your girlfriend, or what were you doing at 5:30 in the morning?
I was waking up on my way to work.
And what time was it when you had your contact with this person, if you remember? I said 5:30. He seems to think it was closer to 6:30.
5:30, 5:45.
Okay. And you know that because of what? Where were you going?
Going to work.
And what time do you normally leave your house to go to work?
It's 6 o'clock, 6:30.
You leave at 6?
Mm-hmm.
So this happened after 6, or? See what I'm saying? We're not sure. As far as do you leave your house at 6 in the morning? So this happened shortly after that, or had you already left your house to be at work at 6?
You know, yes.
Which one? I'm sorry.
I woke up at 5.
And the job that's listed in the PSI about the heavy equipment, is that the job you were going to that day?
Yes, sir.
Okay. Now, tell us your first contact with this individual.
It was right before General McMullen. I was on lane before the fast lane.
And when did you first recognize another car that was involved, the other car that was involved in this?
Shortly after I tried merging to the right lane, because the fast lane was congested.
And when you said the fast lane, that's the left lane, is that
yes,
correct? Okay.
yes.
So you were merging back into the right lane and what happened?
I heard a honk. I merged back to my original lane, which is one lane away from the passing lane. Black Charger pulls alongside me and waving his hands in the air.
Okay, and what did you do as a result of that?
I continued, he swerved into me. I did the same as I swerved back into his lane. I saw a motion in his hands. He was reaching for something. So that's when I merged, looked over to my left side to the fast lane. I saw a small gap, which I cut somebody else off on the fast lane and took off, avoiding the situation.
Okay, now he's told the court the exact opposite, that there was a confrontation and that he moved over and left you in the dust. Is that correct? Is your record? No, that's not correct. Okay. Now, at some point, there was an incident with the gun. Is that we've pled, you've pled to this offense. You understand that you've been charged with aggravated assault and you've pled to that.
Yes, sir.
So there was an incident with the gun that resulted in the injuries he's described. Is that correct?
Yes, sir.
Okay. But at the time, and describe how light is it out there at 5:45, 6 in the morning?
Not very much. The sun's not barely breaking dawn.
And when you said it was on General McMullen, is that different than Highway 90?
No, it's the exit.
The McMullen exit. It's on Highway 90, but at the General McMullen exit.
Yes.
Okay. And how far do you think you traveled with this other car before something happened?
Almost, I would say 1.5 miles, 2 miles.
Okay. So a couple of minutes, this whole ordeal lasted a couple of minutes.
Yes, sir.
Okay. Now, what would you like to, was there anything what would you like to tell the judge? She has to make a decision that's going to affect you obviously tremendously.
Yes, sir.
You've asked for probation. I've explained to you, if you were to get probation, the big part but that is making sure he's financially satisfied with all the money he says he's owed, whatever victim compensation didn't pay to him, those types of things. You understand that, correct?
Yes, sir.
And now your children, I've mentioned that the PSI doesn't reflect it, but you have 2 children. Tell me about them.
Avani's 11 years old and Hazard's 9 years old. I pick them up. I literally just picked them up the weekend before all this incident happened. Me and the mother of my children, we have a good co-parenting. I pick up my kids every weekend, and I have not missed. The last 9 months has been kind of rough for me because I've already missed so many weekends without their.
When you say 9 months, have you been in jail for 9 months?
I'm about to hit 10 months.
Okay. Now, you mentioned also a 17-year-old stepdaughter.
Yes.
Tell me about that.
Aaliyah. She's amazing, man. I've been in her life for the last 4 years. She's told me that I'm pretty much her father, which kind of hits me a lot. Just knowing the fact that I've been there for her life for 4 years. I've been in her graduation, her events, at school events. And so when this incident happened, it really touched down on me because she was 17 at the time. That's also, she was about to turn 18 in August.
What else? Is there anything particularly you'd like to tell the judge before she makes this decision that we haven't already discussed?
I wish none of this would happen. I really do.
Yeah, that's all I have, Judge.
All right, any questions?
You, Judge. Benny. So you were saying before that you were justified in this. Why'd you leave him on the side of the highway?
I panicked. I freaked out.
Why'd you panic, man? If you were on the right, why didn't you stay to help?
I don't know.
Who'd you tell about this?
But other than my girlfriend.
Who's your girlfriend?
Elizabeth Gonzalez.
Are you sure?
Mhm.
Should have asked that you take judicial notice of the stipulated evidence, specifically page 9 of 14 on Sean O'Neill's report. And since it's stipulated, I'm gonna read into the record. It says here, according to Elizabeth, Arnold never mentioned anything about a roadway disturbance and does not know what we are investigating. Elizabeth has no idea what you're talking about. So you just lied again.
I object. He didn't ask him when he told Elizabeth. He's had the last
My question was,
10 months to talk to Elizabeth and tell her about what happened. So if he wants to say, did he talk to anybody about it right at the time, and let him say no, then he can accuse him of not being honest with the court. But until that, there's no reason to believe he's being dishonest with the court.
when did you tell Elizabeth?
Shortly after I was incarcerated.
Okay, so not before August or July?
No.
Okay. So it was after you got arrested was when you finally told her?
Yeah.
Okay. Did you call 911?
No, sir.
Did you report that there was a shooting?
No, sir.
Did you report that someone was trying to run you off the road?
No, sir.
Did you report this to anybody?
No.
If you were justified, why not, don't hide, advertise? Why didn't you tell anybody if you were in the right?
I don't know.
Okay. Let's go to page 13 of 14 in the state stipulated evidence. Did you still have the firearm that you shot Jalen with?
I did not.
You did it?
And I don't have it anymore.
Okay, did you have it before you were arrested?
Before, no.
How long did you have the firearm?
The day after.
Okay, did you get rid of it?
Not technically.
Okay, well, enlighten me. How did you get rid of it?
I just put it a different different location of my person.
Okay, did you manipulate or do anything with the weapon?
No.
Okay, because in the report, it says that it looks like the handgun and the magazine were wiped down. No fingerprints or GSR could be recovered because it had been cleaned. Did you clean the weapon?
No.
So you fired that gun, did nothing with it, and then magically there's no gunshot residue or fingerprints of any kind on it afterwards.
I object once again. It's assuming facts, not evidence. It's assuming that's the same gun. And if they have evidence that's the same gun, that wasn't disclosed in any discovery that I've seen. So
Judges, in the stipulated evidence, I'm just asking him how to explain this in the investigative report. This is all in stipulated evidence already.
Are you saying that this is the same gun that's alleged to have been used? Or the same gun that was used?
That's what I'm trying to inquire into.
All right, so the defense's objection will be sustained until you establish that you're talking about the exact gun that was used in this incident.
Of course, Judge.
Okay.
So the gun that you said you got rid of the day afterwards, was that the gun that you used to shoot Jalen?
Yes.
Okay. And when you got rid of it, according to the report, it was clean of fingerprints and GSR. And you said you had not manipulated the weapon, right?
Nope.
So how is it that you fire a gun and then it's squeaky clean without you doing anything to it?
Mm-hmm.
Magic, right? All right. So you said that Jalen's rendition of events was different.
Mm-hmm.
Previously, you had already testified that you received no evidence of self-defense from your lawyer, and we have jail calls saying that you did. So you were lying about that to the court, right?
I mean, we didn't talk about it. I just know about self-defense.
Okay. Why should the court believe anything you have to say?
object. That's improper question.
Overruled.
Why should the court believe anything you have to say, Mr. Pena?
Because I have no criminal record. I have no reason to lie. This is my life against the court. I mean, I ain't trying to do no time over something that I did not really mean to do.
You didn't call 9. I can tell that you don't want to do time because you didn't report this to anybody. You wiped down the gun. And basically tried to cover all this up. Is that about right?
No.
Then why didn't you come forward and tell somebody about it?
Objection asked and answered.
Sustained.
I'll pass the witness, Judge.
Defense.
Nothing further, Judge.
All right. Any other witnesses?
No, Judge.
All right, the court will hear argument.
Judge stays reserved for a vote.
On behalf of Mr. Pena, Judge, I'm not gonna re-delve into despite the state's bringing it up again. I mean, clearly the court's aware that my client is of the belief that self-defense was perhaps applicable in this case. Now, clearly on the limited amount of testimony you've had today, you certainly couldn't reach that decision. I'm not asking you to, but that's something that plays in his mind. And I believe the actions of the complainant when he says he was driving down the road and stuck something out the window of his car, to which the immediate response was to my client's reacting. I can certainly see how my client could have the impression that perhaps if instructed properly and educated on the laws of self-defense, we might not be standing here today. But more importantly, I think we can tell from the conversations with my client and the previous gentleman that there was a lot going on that morning. I mean, first, if you read the reports, he passes him and slows down to take a picture. If you hear today, he drives off and then slows down so he can catch him. There's a bad driving on everybody's part, perhaps. But I do know that, my client, as he's told the court, feels terribly about what's happened. He did not intend for this to be the result of his actions. However, it is the result of his actions. He has applied for deferred adjudication. He would certainly like you to consider that application. I would bolster that consideration with the fact that he's never been in trouble for anything. Now, in the event that the court denies his application for deferred adjudication, then I would certainly ask the court, when considering the range of punishment, to look below this 25-year cap. I certainly don't think that in this case, with these facts, that number is attributable to what happened, if you will. Once again, he's never been in trouble. He was part of a incident on the roadway that both of these cars were involved in. Both of them were sticking things out of their cars. I do believe that at that time of the morning, it was still pretty dark out. I think he's an excellent candidate for deferred, but if you do not give him deferred, I ask that you consider the lower range of the punishment. He has been in jail 10 months, almost 10 months, waiting for this day. All right, that's all I have, Judge.
State.
That is the amount of distance between this being an aggravated assault and a murder. It's 4 inches. If that shot had been higher than 4 inches, Jalen wouldn't be sitting here. He would have been left by Arnold Pena on the side of that highway to die. And even more so, Jalen wasn't even armed. They searched the vehicle. This man shot an unarmed 17-year-old in the face and has the gall to ask, give me deferred so I can walk right on out that door. Even more so, he says that he's justified, but he doesn't do anything to show that he was in the right. He covered this up. He never told anyone. He never told 911, and the gun was cleaned off. And he said he didn't do anything with the firearm, and he put it away a day afterwards. That is impossible without some kind of tampering by Arnold Pena. And further, Judge, I want to go to page 13 and 14 of Sean O'Neill's report. This is in stipulated evidence, and it goes into admissions that the defendant made on his jail calls. And I quote, referring to Jalen, he put himself in danger. At the end of the day, I did what I did, right? And I took off first. They got me with this shit because they took ballistics on my gun when they took it. And that's the only reason why they pretty much know what happened. The callous disregard of he put himself in danger. They wouldn't have caught me if they had done all of this. The only reason I'm in here is because of ballistics. That is not a person that is apologizing and taking responsibility. That is a person who is upset he got caught. I know that Mr. Pena is talking about his 17-year-old, now 18-year-old stepdaughter. Jalen, 17, 18-year-old is 18-year-old as well. And he's gonna have to deal with what Mr. Pena did for holding up a phone for the rest of his life. So Judge, I am absolutely vehement that deferred is well below what should justice be done here. 5, 10, 15, 20 years is well below what justice requires here. Justice requires that the cap all the way 25 years with the finding of deadly weapon be applied in this case. And that is what I'm going to ask you to do, Judge, to sentence him to the cap, the maximum 25 years with a finding of deadly weapon.
Right. And do parties agree that the amount of restitution is $4,987.42? That's what's in the PSI report.
I agree that's what's in the PSI. I can't state for the veracity of that number, but that's what's in the PSI report.
All right.
4987.42.
And Judge,
So, yes.
I would have to discuss that with Lisa and Jalen about if that's the proper amount. Because I can't, with 6 surgeries, it has to be higher than that.
Okay. Norma?
Yes, ma'am.
Recall this. He's going to recall this in 30 days with regards to the restitution. Is that enough for everybody?
Yes, Judge.
Absolutely.
All right. What date? All right. So we'll address the issues of restitution on June 8th. This is what I want you to realize. One, I read everything. I keep an open mind about everything. And I look at the facts, basically what's in the stipulation, and I consider all the testimony that is given to me. And I understand that you have 0 criminal history, right? So I take all of that in consideration, all the evidence that's presented to me. Okay. So this is what the court is going to do. The court is going to find you guilty, give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. There's to be restitution hearing on June 8, 2026. There's an affirmative finding of deadly weapon, and the court will sentence you to 15 years. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I would like to address that.
Yes.
Yes, at the time he signed it, he had no rights to appeal, but having had the motion to withdraw the plea, I have, and I'm going to tender to the court a notice of appeal specifically on that issue. So
Right. And
I
could you
don't
do me a
believe that.
favor? Could you, because the trial court certification, I think was
Can we get a different
originally,
one?
yes,
I would prefer that if you don't mind.
yes, because that was originally signed by Judge Angelini because he took the plea.
Okay.
All right. All right. So the trial court certification of defendant's rights to appeal, you do have a right to appeal that's related to any type of pretrial motions that were heard and that were ruled upon. And you did have pretrial motions in this case that were heard and ruled upon by me. The motion to withdraw your plea being one of them. You understand?
Yes, ma'am.
Okay. Now, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Okay. And so we'll be back on June 8th to determine restitution amount. Your attorney will be given information on what the state is proposing restitution be. And if y'all can't reach an agreement on that, I'll make a decision. Okay. All right. Thank you.
And Judge, at this time, I'd like to tender to the court if I could. First, the notice of appeal on my client's behalf, and then secondly, my motion to withdraw solely so the court can appoint him an appellate attorney to handle.
All right. So,
But I'll stay on for the purposes of the restitution hearing. I don't want to delay his appellate rights. Since he's been sentenced today, the clock starts. So maybe we can maybe you can make my notice effective June the 8th or something.
Okay. And can I have the trial court
Oh, I'm
certificate?
sorry. Yeah.
That's okay. What's that? And Norma? Yes. Oh, there's no order, but Norma appointed appellate attorney and see if that appellate attorney can be here on June 8th, whoever it may be, so that you'll have a chance to speak with them at that time.
Thank you.
And then your motion to withdraw,
Just hold
we'll
on.
deal
to
with it
Okay,
after that, yes.
That's fine. Thank you.
So on your case, Zavala, he didn't make transport. All right, recall May 4th.
I was gonna recall potentially just for Monday, only because I have another client in here on Monday.
All right.
Is that May 4th? I'm sorry.
Yes,
It
May
feels like a
Today's
long
not-
time away.
She needs to sign it. Okay, all right, see you then.
Sounds good, Judge. Judge, also, family violence
Right.
wanted to bring something up.
May we approach,
Yes.
since he's still here on an off docket matter?
Yes.
Case of Mr. De Leon's client, Martha Frias, was set on the jury trial docket on May the 12th. We have a motion for continuance, Your Honor. We would like to argue that we have an essential witness who is unavailable that week at our sane nurse, Ms. Shannon Murphy, who is on an approved vacation for that week. She is an essential necessary witness as she is looking to complete the defendant's SANE exam. And she is essential in that she's needed to establish the first link in the chain of custody for any DNA evidence that will be entered into.
And is there DNA evidence?
Yes.
Yeah, there is.
Okay.
Judge, I can tell you the court that I have a murder trial on 437 set the same day. Specially set, so I'm not jumping in up and down opposed to the defense's, the state's motion.
All right. Well, is your client is on bond, right?
Yes.
All right, so if you want to have him by Zoom on Monday, because he has to be here for me to rule on it.
Okay.
And then I'll take care of it. All right, thank you.
Thank you, Judge.
Angela Williams?
Angela Williams. Court is calling 2026 CR 0000269 State versus Angela Williams. Can I have parties announced for the record for the state?
Lauren Esposito for the state.
Roger Bettis for Ms. Williams, Your Honor.
And are you Miss Williams?
That is correct, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Williams, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
I believe, Judge, we're proceeding on the lesser included offense of attempted
It's a
injury.
class A misdemeanor.
No, I think you all are just proceeding on assault bodily injury.
Oh, yes, Judge, we are proceeding on assault bodily injury. Apologies.
No problem. And I understand you're probably not the one who worked out the plea.
No, Judge.
So I only know because I'm reading the admonishments. Any objection?
No objections, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor, but could I ask you a question?
Sure.
What you just said to abolish, assault to bodily injury, what do that mean?
Do you want to talk to your client about that?
Yes, Your Honor.
All right, do you understand it?
Yes, Your Honor.
And has your attorney explained that to you sufficiently?
Yes, Your Honor.
All right, so the state is proceeding on the less included offense of assault bodily injury, assault causing bodily injury as a class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do believe so.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Williams, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
All right, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of assault bodily injury. Punishment is to be assessed at 1 year in the Bexar County Jail. There's an $800 fine, and the state is recommending community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense of state?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing it, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 200 hours community service restitution, no contact with the complainant, and anger management. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, as to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offer States Exhibit 1 and all attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, the gentleman that was involved in this is a neighbor. They had a relationship over time. There was a issue pertaining to the taking of certain items. And that was what the issue was, what the misunderstanding was. She's 57 years old. She's disabled. She's been a certified nursing assistant since she was 20 years old. This is the first issue that has ever risen in her life. She's a very pleasant person. Her nickname is, I think, Queen. And we would just ask that we would be granted the probation. And if you could consider, she's not the most physically mobile person. So we believe that, and nor does she have the ample resources because she receives a check. If you could consider lessening the fine and the community service, Your Honor.
All right. This is what the court will do. The court is going to sentence you to 1 year in the Bexar County Jail, suspended and probated for 1 year. There's an $800 fine that will be probated. There's to be no contact with the complainant. Probation, that. Thank you. There's to be 200 hours of community service restitution. I'm going to order anger management. Once anger management is completed, do you have any grandchildren that stay with you?
No, I live alone, Your Honor.
All right. Once anger management is completed, the community service hours will be deemed satisfied. Regular reporting by Zoom or in person, regular UAs. Do you receive SSI or?
Yes, Your Honor.
All right, proof of SSI within 45 days. Field visits 1 time per month for 2 months. Probation, is there anything else?
No, Judge.
All right, do you have any weapons in your home?
No, ma'am.
All right. So there'll be no possession of a firearm.
Yes, ma'am. Yes, Your Honor.
Is there anything else you need from the court to be successful?
Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you
Your Honor.
understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
Yes, Your Honor.
All right, good luck to you, okay?
Thank you.
You're welcome. All right, the parties on the person with the engagement ring. All right, you all asked me to reach out.
Mhm.
I have reached out. So the ring is a white colored ring with white colored stones. And I'm assuming, is that the ring?
Yeah, there's picture, we have pictures of it, right? It's kind of.
Can I
an in-
talk to the complaint witness real quick,
Sure.
Judge?
It's an interesting engagement ring that
Mhm.
kind of like comes apart in a weird way.
Okay. All right. Do y'all mind if I take a photo of this and send this and find out if this is the exact?
No objection.
No objections, absolutely.
Let me see.
Oh, for a second, wait, that's a photo of a photo, so we gotta authenticate the photo. The photo's up, no. Don't get into the rules of evidence.
We don't need to. we don't need to-
And Judge, just wanted to reinforce that it's two rings. It's the engagement band and the wedding band that we're trying to reacquire.
So is this the total of the engagement and the,
No, ma'am, the photo that I handed over is.
It's just the engagement?
Yes, ma'am.
all right, because sometimes I know it attaches.
Yes, ma'am.
Let me ask.
I've actually never got like you got the engagement band, and she loved it so much that she never got like the wedding band. So we're just like, okay, eternal fiance.
Thank you.
Right, so this is what needs to happen. And I know this is a never ending story, but
It's a little
my
like. Lord of the Rings.
understanding,
Yeah.
you all want the engagement ring back.
Yes, ma'am.
All right, so that's in the property room. Now, it is the inmate's property, right? Because it came in with him. So an order needs to be filed. And maybe whoever is that, does anybody know who that inmate's attorney is?
So
here-
he requested one, they haven't appointed him one yet, so he doesn't have an attorney. And
Which court is it out of?
175th, but I don't know if they're gonna get to it at all because he's dealing with the feds right now.
No, they should still
I mean,
appoint him an attorney, huh?
They should, but
He has to be appointed counsel.
Because here's the thing. That ring,
That maybe you could,
oh, let me just tell you. Oh, yeah, let's do the compliance. Come forward with the compliance. Who is that?
It's Albert Gunther, Judge. Ms. Gay has been appointed to Mr. Gunther, Judge.
Oh, awesome.
Good
Mr.
afternoon,
Gunther,
Judge.
how's it going?
I'm doing good. How are you?
Oh, I'm doing okay. At least it's not 5:30, so we're all doing good.
So Judge, we're here today because we received an order for transfer from felony drug court. At this time, Mr. Gunther does not want to continue participation in felony drug court and is voluntarily withdrawing. There were some concerns that he has spoken with his attorney about that we probably just want to talk through everything.
Because according to the ruling, there was a violation of condition number 2. The court found it true, referred you to felony drug court, and if not accepted, then you were to go to SAT.
So Judge, he has been a participant in felony drug court since December of 2025.
Okay.
He was ordered lifetime recovery inpatient. He entered lifetime on December 31st of 2025 and completed that on the 30th of last month. He was then transferred over to a sober living facility, but some issues arose at that sober living facility in which he was evicted. And then I think that's where we are now.
Okay.
Better than he looked before.
Oh, no, he looks great.
And we, with the intensive supervision, you know that we do check on them very often. And if there are any issues, we will implore Mr. Gunther to come forward and if he needs additional help.
All right. And let me just tell you, I want to commend you because there are some people, when they hit a bump in the road, they just disappear. Whether it's their fault or not their fault, sometimes they're like, oh, life is bad. they throw up their hands and just call it a day. So I appreciate you're not doing that and trying to say, okay, here I am. Maybe I was treated badly, because that happens in life.
Yes.
And how you respond to it tells me where you are in your sobriety. So thank you for that.
Thank you.
All right. So is there anything else you need from the court?
Just your help whenever I need it.
All right, awesome. Okay, so once you sign those amended conditions, you are done today, and thank you for your patience today.
Thank you. And today is my 7-month sobriety.
Oh, congratulations. That's a lot, right? Oh, no, I always tell everybody, every single day, each day is a day. So congratulations. All right, thank you. So what is happening with this case?
Judge, we just got the initial offer. I reviewed it with my client. He'd like an opportunity to contemplate it.
All right, do you have all discovery?
I believe everything. I believe we have everything.
How old are you?
23.
All right, Ms. Ferguson, recall this in 30 days for a plea deadline date.
Yes, that'd be May 28th.
All right, thank you.
Thank you, Judge.
Keonis. Court is calling 2026 CR 00067 State versus Victor Keonis. Can I have parties announced for the record?
Brandon Pereira for the state.
Afternoon, Judge. Robert Gear for defendant Victor Quinones. We're ready.
Oh, I'm so sorry, Cindy. I know you had left, but now I thought you had come in. All right, court is calling 2026 CR 00067 State versus Victor Keonis. Can I have parties announced?
Brandon Pereira for the state.
Robert Gear for defendant Victor Quinones, and we're ready.
And are you Mr. Keonis?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, we did, Judge.
Court will find that the state is in compliance with discovery. Mr. Keonis, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Keonis, did you review the true bill? I'm sorry, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance penalty group 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe that he was and is.
Mr. Keonis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,000 fine probated, and the state recommends community supervision. Did you understand that to be your plea?
Yes, ma'am.
State defense?
Yes, Judge.
That is
Did you-
true, Judge.
Did you review that's okay. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
There have not been, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be 100 hours of community service restitution. No contact with Herlinda Hernandez, the DOEP course, and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Judge, we offer state exhibit number 1 and all attachments.
Defense is reviewed, Judge. We have no objections.
Did you review the state, you may be excused? Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge, and we'll waive a PSI.
Anything you wish to say on behalf of your client?
Judge, the defense would respectfully request that the court follow the plea bargain.
All right, do you have any children?
No, ma'am.
All right, do you live by yourself?
No, I live with my sister.
Does she have any children?
No, ma'am.
Are there any minors in the home? All right, there's $1,000 fine to be probated. The court will sentence you to 3 years in the prison, suspended and probated for 3 years, regular reporting by Zoom or in person, regular random UAs, proof of employment within 35 days of release, no employment as a home health care provider or with minors, no contact with Herlinda Hernandez, TAP evaluation out of custody, follow TAP recommendations, no residing in households with minors, field visits 1 time per month for 6 months, 100 hours of community service restitution. Court will deduct 50 hours upon completion of the DOEP course. The remaining 50 hours will be deducted at 1 hour for every sober support meeting completed. Probation, is there anything else?
Employment, Judge?
Ah,
Oh, yeah, you said
yes, okay.
You said 45 days, nothing else.
All right, thank you. Is there anything else you need from the court to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
Jessica Navarro. All right, if you'll come forward, please, Jessica Navarro. All right, so are you employed?
I just got a job.
All right, are you able to Zoom?
Yes.
All right, so what are we gonna do? Your attorney is out of county. I've just been informed of that now.
Okay.
We're gonna recall you back for next week, Thursday. And if you can Zoom in, you'll be allowed to Zoom, okay?
Okay, would I get the,
They're gonna give you the link and everything.
okay, thank you, Your Honor.
All right, thank you. They're gonna give you a reset form, okay?
Yes, ma'am, thank you.
All right, the people on the ring. I'm just calling it the ring. We're gonna try to get I say we, they're gonna try to get you the engagement ring back. So of course, there are other things now that happen. Now everybody knows where at least the engagement ring is. It appears that it's not the band as well, because they only said 1 ring, or sometimes people don't know. So we're going to recall this back in May. It should be easy for somebody in property crimes.
Yeah, I would think it's beyond the scope of us, at this point.
Let me just tell you how it should work legally.
We will see.
All right.
So is there anything that you would like me to file in terms of the court doing an order or?
No,
or
I mean,
leave it in the hands of
It'd be the
the
same
property
thing.
crimes?
basically the police has to do it unless that person gets an attorney. And so it's out of the 175th. So they should assign him attorney for the case that he has here in Bear County. Then that attorney can talk to him, but
I'm sure you couldn't be assigned to it because that would be.
No. it'd be
Oh, that's a
way too-
conflict.
way too much of a
Yeah.
conflict.
right. So Norma, let's call this back on May 28th. You all should have the ring by then.
Oh, we will see. We have one ring. We'll have we know where one ring is. We'll see where the other ring is.
Well, yeah, actually, do the rings come apart at all?
Yeah, there's a.
Yeah, they're separate
They're
bands.
separate bands.
Yeah, so one band is in the property room and the other band is with Bonnie Doffler.
I think the judge just read that he only had one ring
Yeah,
the whole
two
time.
necklaces in one ring, I think.
Well, they're just saying it's one ring.
Oh,
Maybe the ring's on the necklace. That's what I heard.
yeah, I think I remember you telling me that. So we'll find it.
So I tell you what, though, and that's Bunny with an IE.
So
B-O-N-N-I-E.
BONNIE and then Davila.
Yes.
Okay.
All right, thank you.
Perfect.
Thank you. Thanks. All right, the court is calling 2025 CR 008217, 2025 CR 008219, 2025 CR 008221, State versus Pierce. Pearson, can I have parties announced for the record?
Lauren Espinoza for the state. Monica Anna Guerrero for Pierce Person.
All right. And are you Mr. Pearson?
Yes, ma'am.
All right. Defense, do you have any objections to your client appearing by Zoom?
No objections.
All right. In each of these cause numbers, the defense has filed a motion to quash the indictments. State, have you had a chance to review the motions?
Yes.
All right. And State, are you objecting to the motion?
I suppose so, Judge. For full disclosure, I talked with defense counsel earlier today. I did file a motion to amend said indictments, adding a time at approximate 7 p.m. to each indictment. I just wasn't sure what the order was of proceeding, if we proceed with the motion to quash or just motion, I don't know. I think she objects because it was within 7 days, not 10, so yes, I object to the motion to quash, but also I don't know if I'm to urge this, I guess is.
Oh, okay. All right. So where we are now is we're just dealing strictly with the motion to quash because she doesn't have proper notice of the amendments.
Hey, Judge.
So with regards to that and not having the amendments, State, do you believe that a motion to quash and the granting of that is appropriate or no?
No, Judge. No.
All right. So I'll hear your argument, counsel.
Sure, thank you.
So as the court and the state are aware, we have been before this court several times because of Mr. Person's mental health at the time of the incident. And specifically, we've been referred to two mental health treatment or two treatment courts that have been denied by the state. Mr. Person's culpable mental state at the time of the incident is really at the heart of this case and this motion. This case arises from a night on November the 13th, 2024, where Mr. Person was having a severe mental break in the town of St. Hedwig. This is outside of the San Antonio city limits. It borders Converse. Mr. Person and his family lived at the very back of the neighborhood it's a new construction neighborhood called Abbott Place. And it was on a dead-end street facing undeveloped fields with trees and pastures and even ponds out in the fields. The day after this mental health crisis, two complaining witnesses in his neighborhood of Abbott Place at 13693 Paxton Boulevard, as named in the indictment, and at 13689 Paxton Boulevard. Those one other complaining witness in the neighborhood. Yes.
Okay. All right. Let's
Okay.
continue.
To round that out, there are three complaining witnesses, and the complaining witnesses and Mr. Person don't know each other. That's background for the court. With the court's permission, I would like to show, and I've showed these to the state, just a map so the court can get a bearing of what we're talking about in this case. If they're two Google Earth maps, I'm not presenting them as exhibits, just for judicial notice and for the court's perspective to be able to
I mean, I feel like that's going a little bit outside the scope of a motion to quash. The motion to quash purpose is to say that the charging instrument is deficient, so I'm not sure.
It's
The
for
utility of the map.
I'll get there. It is for background. The heart of this motion is, the heart of this motion is that the state has failed in their indictment to plead with sufficient certainty, with sufficient notice to give the defense an opportunity to prepare adequate defense of the culpable mental state of knowingly. The state is required to plead that the defendant, that Mr. Person knowingly discharged a firearm at or in the direction of a house.
All right, so
And yes,
this is what I'll tell
yes.
everyone, my understanding of the law and the motion to quash. Any facts about whether or not the area where he's alleged to have committed any type of offense, and I'm not saying that you committed an offense because we're
Yep.
just hearing the motion to quash. Any evidence of whether or not a location was abandoned or whether it was intentional or reckless, those are fact issues. With the motion to quash, my role is to look at the indictment and look at the four corners of the indictment and see if the indictment gives sufficient notice, if that's what your argument is. But it's not to figure out the facts, like, was this an abandoned place? Was this on the outskirts? Was it new building and nobody would be there? That's something
I
for a
understand.
jury.
And I'll try to proceed and stick to just the four corners.
Sure.
And that's exactly the problem that I've had with this case from the beginning in 2024 when I received the case. Is I've been raising the same issue as to what circumstances, how and by what means and manner does the state have to show that Mr. Person knowingly discharged a firearm at or in the direction of a home. What the state has pled in the indictment, and they are allowed to track the statute, yes, to a certain degree, but they cannot just regurgitate the statute. And what Rodriguez state calls and I have the opinion here, is a tautology. The indictment cannot state, and that this was actually a deadly weapon case coming out of San Antonio, I believe, that addressed the reckless deadly conduct. And in that case, the court held that, in that case, they struck down an indictment because basically what the state had pled was that the defendant recklessly discharged a firearm because he discharged a firearm. And in this case, that's all that the indictment says here, is that Mr. Person did knowingly discharge a firearm at or in the direction of a habitation and was reckless as to whether the habitation was occupied, namely by or because he discharged a firearm at a habitation. There's a circular argument, or it's a circular allegation that gives me as a defense counsel and defendant no indication of what knowing conduct, just because a home may have been struck by some kind of gunfire, does not get the state to, does not establish the mental state that the state is required to provide. And we don't have a notice of what evidence there is. And that's been my question all along. Not even what evidence, but what circumstances, what means and manner, other than the fact that the defendant, as they allege, discharged a firearm, as they allege, at habitation, because he discharged a firearm at habitation. It sounds very confusing. I get it. But I don't have anything other than, I don't know in what way he would have discharged a firearm at a home, at this home, and at this home in various different locations and in the ways they were. And that's why I was trying to give the court some background as to, I don't have no notice on what the state is going to, what the state's basis is for knowingly.
All right. Thank you. All right, state.
Yes, Judge. The state will concede that
generally, an indictment or information is sufficient when it tracks the statute. Now, there is an exception that exists when an offense or a statute prescribes the mental state of recklessness or criminal negligence. At that point, the state is required to put a manner and means and needs to be more descriptive. So here in this case, we have the charge that requires essentially two different culpable mental states. So we have the first part of the statute that requires knowing discharge of a firearm at or in the direction of, and then it gives A or B. Here it's under B, which would be a habitation. And then the second mental state and is reckless as to whether that habitation is occupied. The aspect of knowingly, Judge, is how he knowingly discharged is shown through evidence. That's for the fact finder to determine. Whereas the element of recklessness, as the code tells the state we must do, we are to allege manner and means of doing that. And we've done that here. The state judge is not required to allege evidentiary facts in the charging instrument, and we're not required to lay out its case unless it falls into the required mental state. So defense's argument of we are not properly alleging how he knowingly discharged, that would require us to lay out our case, which we're not required to do, but we do have the requisite manner and means regarding the recklessness element, culpable mental state of the fact. So because of this, Judge, we would urge that you deny defense's motion to quash the indictments as they are sufficiently pled. And I would disagree with it. There are two prongs to it, that he knowingly discharged firearm out in the direction of the house, and he was reckless as to whether the habitation was occupied. But other than, there is no manner and means for reckless either. And she is right, there is a higher standard for recklessness for them to provide circumstances surrounding that mental conduct. But as to that, there is absolutely nothing in the indictment that goes to the reckless, a reckless disregard of whether a habitation was occupied or not. Also, with regard to Rodriguez, the case that we discussed, it sets a floor for that tautology argument that it cannot be circular. And then further, the Constitution, the Texas Constitution and the US Constitution allows us notice and certainty as to the alleged culpable mental state. I just have nothing to go on with this. I really, and I think it's telling that the state did actually file a motion to leave to amend their indictment, and they only added, their proposed amendment is to add a timestamp. That doesn't go any.
Oh, I'm not even looking at the amended.
But I would like to say it is important that they have asked the court for motion for leave to amend. That being said, even if it was granted, we would object again. I know you're not addressing that, but that does go to the heart of our case, and that something needs to be. I need more notice of how we're going to put on a defense of this case that he knowingly shot at or in the direction of a house, and that he was reckless as to each habitation being occupied or not. And for these reasons, we are requesting that the court quash all three indictments. The indictments allege that something happened. They don't allege that Mr. Person knowingly made it happen and that he was reckless.
Okay. All right. State, the defense has tendered case law, State v. Rodriguez. If you want a chance to continue present case law, you're more than welcome to do that. And if you all present if there are other case law you all want me to review, let me know. And I will give you all time to do that. And when is a good day for you to come back, counsel? And of course, your client can appear by Zoom.
Okay. When are we thinking? What kind of timeline are we thinking?
Oh, no, just let me know whenever, if there's more information you want to present to me, any more case law for me to consider.
Okay.
Just let me know.
Yeah, absolutely. I'd like an opportunity to for the case law, some more help, 10 days.
Oh, sure. And if you'll share this with the state.
Is that what you Yeah.
Oh, you already have that. Okay. And then if you all want to, both of you all have my email. If you want to send it by email, but when you're sending by email, just make sure all parties are included. And if there is more case law that you want me to review, I'll review it and then make a decision.
Okay, all right.
All
So
right.
it's set for to come back in 10 days for your
Oh,
decision.
if that's enough time for you all.
Okay,
Yeah. Because I know sometimes people are like, oh, Judge, we want you to consider something else. So if there's something else
okay,
you want me to consider, I'll consider it.
okay. Thank you, Judge.
All right. So Norma,
Yes, ma'am.
they're asking for 10 days. And Mr. Pearson, thank you so much for your patience.
Yes, ma'am,
It's been a
absolutely.
busy day today, and there were some cases that had witnesses, so.
Yes, ma'am.
Can we put it on May 11th?
Is May 11th enough time for you all? I know how it is to be a defense attorney. You don't have an appellate staff. You are your appellate staff.
Yeah, yeah, I think 10 days is plenty.
All right, so May 11th, that will not be the upcoming week, but the following week, and that's a Monday.
Okay.
So that's enough time for everyone?
Yes.
All right, so each party, just for my benefit, the last day that you send me case law, please let that be May 8th,
Okay.
and then I'll look at it over the weekend. All right.
Thank you.
All right, thank you.
Thanks.
All right, Mr. Pearson, you can come back. It'll be the same link, and we'll have you back on May 11th.
Yes, ma'am. Thank you, Judge.
All right, you're welcome. Oh, and then defense. If for some reason I don't rule in your favor, if you'll be prepared to hear her motion to amend. And if y'all have case law you want me to review on that, you're more than welcome to submit that as well.
Perfect. Okay.
All right.
Thank you.
I haven't made a decision, but I just want everybody to be ready.
Do I need to file, I think I objected on the record. Do I need to file a written objection? Okay.
No, just make sure that it's clear on the record.
Okay, thank you.
All right. Who else is next? Tony,
Yes.
who is your client?
Fine.
Number, what page is Tony's client on?
It is Schrodinger's file. It's like it's there.
Oh,
It's not there.
I see it. What is happening with this case, Tony?
I pulled up, I'll just start, I looked into it and I pulled up the case. We are missing a few documents from DPS, so I sent a request for those and I will review and give Mr. Hernandez an offer ASAP.
Okay, so.
In addition to that, Judge, we had filed a motion for bail reduction that we had conferred about. Satan and I had conferred about.
As for that, I would just defer to the court. I did explain to Mr. Hernandez, his client would need to provide testimony about what
Yes.
he can afford.
All right, let's come down. And Norma, recall this in 30 days for discovery.
Yes, ma'am. One second. I was in the middle of something. I'll give it to you in just a moment, Judge.
Okay, all right, the court is calling 2026 CR 002694 State versus Brian Ruiz. Can I have parties announced?
State.
I'm on behalf of Mr. Ruiz.
And are you Mr. Ruiz?
Yes, ma'am.
All right, we're here. The defense has filed a motion for a bail reduction. Your bond is currently set at $40,000. State, have you had a chance to review the motion?
Yes, sir.
All right, and State, are you ready to proceed? All right, defense, you may proceed.
Your Honor, we called Brian Keith Reed.
Can you raise your right hand for me, please?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Brian Keith Breeze.
All right, you may proceed.
Brian, you understand that you're currently being held on a $40,000 bail, or bond, is that correct?
Yes.
Now, you have on your own previously filed writ of habeas corpus seeking bond reduction, is that correct?
Yes.
Recently, your mother hired me and asked me to assist you, to represent you and to go forward with this bond reduction, is that right?
Yes.
Okay. You and your family have made attempts to make this $40,000 bond, is that correct?
Yes.
And my understanding is that your family has reached out to different bondsmen, and what is the response that they've received?
they want 10% of the 40,000 and they want collateral, some kind of deed to the house or car title or something like that.
Now, your mother is in Houston, Texas, is that right?
Yes.
Where she lives?
Yes,
And is she on a fixed income?
yes, she's retired.
Is she able to assist you in getting money together for this bond?
She's trying, but she can't afford 10% of 40,000.
In fact, she's indicated that she can get another $500 together. Is that about right?
Yes,
But she is not able to come to San Antonio and sign off with any bonds. Is that right?
yes.
Now, you do have some family here in San Antonio, right? You have two daughters. that are
My two
adults.
daughters.
And how old are they?
My oldest one she just turned 18 and my youngest is 16.
So the 18-year-old, does she own any real estate?
No,
Does she own vehicles or
no,
to your knowledge, does she own anything that she could borrow in order to raise money for you?
no,
Now, do you own any real estate?
no,
Do you own any vehicles?
no,
Okay, do you have any type of property that you could borrow against or sell in order to raise the $4,000 for the bond?
no.
Now, you've been in jail since December 28th, is that right?
Yes,
And what kind of work were you doing prior to your arrest?
carpentry, construction, remodeling, landscaping,
Were you-
handyman type work.
Did you have any employees?
I work for my neighbor and some Donnie Horderman off and on, and then some of my neighbors, I do their landscaping.
Okay, but you were working for them, right?
Yeah,
They weren't working for you.
yeah, I'm work.
Okay. And obviously, you've not been able to work since December 28th, is that right?
Yes.
Okay.
Because I've been in jail.
You were originally appointed an attorney, so you filled out the application and you were determined to be indigent at the time, is that right?
Yes,
Fair to say that your monthly living expenses are equal to or less than your income, is that correct?
Yeah.
When you're outside?
yes.
Okay. You're asking the court to reduce the bond. How much money do you think you and your family can, what size bond can you and your family?
10,000, maybe? Maybe,
Something along that line.
yeah.
Okay. Good passive income.
All right, any questions?
Just a few. Hi, Mr. Ruiz. My name is Lauren Espinoza. I just have a few questions for you, okay?
Listen,
Regarding bondsmen, have y'all shopped around for bondsmen or did y'all only go to the one that required 10%?
but my mom, she was calling around, so I don't know exactly how many she called or they were wanting collateral title to the house or title to vehicles
So
and
you-
co-signer.
So you know more than one she tried.
Yes.
Okay. And then regarding your family members, do you know them to have any savings accounts?
My daughters, I don't think so.
Okay, no further questions, Judge.
All right,
Thank you.
any further questions?
No, Your Honor.
Any objection to the court asking a few questions
No,
for
Your Honor.
purposes of perhaps setting conditions?
No, Your Honor.
All right. Have you ever had any type of mental health diagnosis?
No, ma'am.
All right. Any type of drug use in the past?
No, ma'am.
Okay, no marijuana, no alcohol,
Smoke weed occasionally and drank some socially.
all right, but nothing that you would consider rising to the level of an addiction?
No, no.
All right. And if you were able to make bond, who would you be staying with?
My dad's house. He passed away and left me the house.
All right, any minors in that home?
No, my daughters live with their mom, my ex-wife.
Okay. All right, any other questions?
No, Your Honor.
Any other questions? Okay. Any other witnesses?
No, Your Honor.
All right, state any evidence?
Judge, we just have the prior history of Mr. Ruiz. It is 2 state jail felonies and a misdemeanor criminal mischief. But other than that, I don't see anything else.
Okay. All right, and the defense is asking that bond be set in $40,000. State, are you in agreement to reducing or no?
I don't necessarily object, Judge. I defer to the court.
All right. This is what the court is going to do.
You know, depending on the street size and stuff.
All right. This is what the court is going to do. Court is going to set the bond at $10,000. Anything else?
Oh, we have to.
All right, Norma, what date for them to come back?
28.
All right, we're going to come back on May 20th. You need to make sure that you're on time.
Yes,
And
ma'am.
if there's a sidewalk provided, walk on it. If there's a sidewalk provided and you're on the bicycle, you're not allowed to ride on it.
And lights on the bike.
And lights on the
Yes.
bike.
Yes.
All right, so
Yes.
Yeah. So if you'll sign that and you will be back then.